Good evening, all of you. So, we will be starting the discussion of prelims, polity and governance for 5 years. Okay, 2019, 20, 21, 22 and 23. Okay. Second thing is, there are few questions, very few questions, 3 to 4, where the answer keys after being released by UPSC, some answers have differed. Okay, so we have actually rectified and we will be strictly adhering to the answer key released by Union Public Service Commission. Okay. Third important thing, the answer keys for the civil services examination paper 1, GS paper 1 prelims has not been released till date. They will release after the Shraddh. Okay. Next year. Okay. So there would be some elements of subjectivity. Okay. No doubt about that, because there are few questions that are relative and that are quite understandable that there would be an element of relativity in them. So other than 23, we already have the answer key that has been released by UPSC. Okay. So the point is, before we venture into the academic discussion of 2019 to 2023, first of all, I can see many tensed faces. क्या भाई इसमें दुखी होने की बात क्या है? Be happy. There is a saying that be sincere, don't be serious. Okay. So now let's understand. First of all, there is a sense of what you call, there is a sense of palpitation that the question was tough. Okay. Please understand this important point. I'm talking with respect to 2023. This is not an optional thing. Okay. If in optional the question is tough, that places you at disadvantage. Why? Because maybe possible the questions are not tough for other optional and they are tough for you, then it places you at an element of disadvantage. There is no point of being sad about prelim, because it is an exam which is a relatable thing. So if the prelims part is tough, it is tough for everyone, and I am interacting with thousands of students. I do not find much what spectrum of intellectual difference between students from wavelength 0 to 100. There is hardly much difference in if the people working hard. So I don't find a single reason to be upset about the fact that with respect to this, questions were tough. If the questions were tough, or if the questions were more on what you call interpretation as well as deep facts, we must relish them, because this is a relative thing. It was tough for everyone. Okay, there is not a single reason to be sad about that. Another important thing, if the questions would have been easy, then of course the cutoff would also go high. So 2013 civil services examination, the cutoff for prelims, GS prelims combined when CSAT used to happen together was 241. 241 was the cutoff in 2013 civil services examination, because CSAT was also counted. Okay, so now that they make it just a qualifying thing, what I'm trying to bring, there is no need to get upset because it is tough for everyone. Okay, so before we start with the academic part, I have the PDF with me that we'll be referring to. First, let us briefly, very calmly understand what is required from the current perspective. Okay, that is something which is pertinent. Okay, so after going through the same set of questions in last 5 years so many times, what are the common, what you call, conclusion that I have derived, and from the experience also I'll be talking about certain things. Okay, there are few questions undoubtedly which the cutoff hovers around 88-90. In the worst of scenario, this time we don't have the cutoff, but even if we assume that to be 80, okay, so the cutoff is, if the cutoff is 40%, okay, if the cutoff is, getting my point, 40%, so it is not possible for any human being, even if the person is given internet in the examination hall, to secure all the questions correctly, because there are levels of interpretation and there are few questions which are brutally tough that actually, thank you. So the point is, with respect to this, now let's understand few questions which you see at first go have absolute highest level of difficulty and facts. Some questions, few 5 to 10% questions, there is no need to worry about them. Those insightful deep questions, it is not possible to get them correct from anyone's perspective. Even if you get them correct, Okay, next year they would be asking something more random. Okay, sometimes they are asking 4 questions from sports. Okay, they asked a question from ICC Test Championship. They asked a question from US, what you call Tiger Woods receiving the award for the highest number of times. They asked a question from New Zealand. So I'll make you see those questions. There would be few questions from uncertain, unpredictable areas, which is no need to worry because it is uncertain and unpredictable for everyone. Okay, so the answer key and the question, the cutoff that is going, if at maximum it is 100. So even if there are few questions which seem to be very tough, there is no need to worry about. Now what should be an intelligent start? How you should go about that? Okay. So if we see the syllabus of UPSC, then you will conclude that in the prelims part of the examination, they have not detailed out the syllabus. In the prelims part of the examination, they have not given a very comprehensive syllabus. In the mains, they have been very benign and kind, and they have given a very comprehensive syllabus. Every single term that you have used in GS paper 2 syllabus is actually a potential what you call area of UPSC's direct question. Like there is a term mentioned, role of civil services in democracy, pressure groups. All these terms that are mentioned in the syllabus actually leads to a question that is being framed. But in prelims, they have mentioned Indian constitution, political system, panchayati raj, rights issue, etc. So in prelims, they have given a broad framework. They have not detailed out the syllabus in a very comprehensive way. So there is no need to worry. Whatever you are doing within that framework, only the questions would be coming. What should be an intelligent thing? First, without an iota of doubt, every student should be see, the purpose of the entire discussion is not to let you be aware about the facts. We live in an era of bombardment of information. You are already aware with a lot of facts, and the purpose is to prepare you for the future. That is the most important thing. The purpose is to get you, and I can talk about one topic for 3 hours. That is not the purpose. How you may be able to intelligently speculate in the coming years and how you should be guiding anchoring your preparation, that is the most important thing. So first thing what you need to do is you need to go through at least these 4 NCERT textbooks, okay, which are absolute prerequisite. In last 5 to 7 years, at least they have consistently asked 1 or 2 questions from these NCERTs. So these 4 NCERTs I find are oxygen. First is Democratic Politics Part 1. Second is Democratic Politics Part 2. Third is Indian Constitution at Work. And fourth is Political Theory. Undoubtedly, you cannot imagine to prepare without covering these 4 NCERTs. When we will be having discussion, I will make you point out that this question has been lifted from that particular NCERT. So consistently, they have been asking questions directly from NCERTs. So 4 NCERTs you need to cover, okay? One is Democratic Politics Part 1 as well as Part 2. These are 2 NCERTs. Then you have Indian Constitution at Work. And then you have my favorite NCERT, that is Political Theory. So this doesn't have political theory of Paul Science or sociology, Marx or Weber, no. They have actually basic terms that we use in the Constitution, basic terms that are in the constitutional jurisprudence every single day. What do you mean by liberty, equality, fraternity, constitutionalism, principle of secularism, negative aspects of liberty, positive aspects of liberty, how expression, what is the idea of justice, social, economic and political justice, what is the idea of welfare state, what do you mean by fraternity. All these key terms that are in commonsensical discussion every single day have been very exhaustively detailed out in this NCERT in a very, very simple and what you call understanding way. Okay, so this book, that is Political Theory, they have directly asked in last 5 to 7 years, if I can correctly recollect, at least 5 times they have asked a question from this NCERT, one question. So even if they are asking one question from this NCERT consistently, it becomes very, very important for me. So these 4, Babu, ye 4 NCERTs you need to cover. That is Democratic Politics Part 1, Democratic Politics Part 2, then Indian Constitution at Work, and then you have Political Theory. Ek aur baat, you will tend to assume that these NCERTs I know. But UPSC has this Machiavellian or what you call Mephistophelian or Luciferian habit of what you call enjoying over your what you call conviction. NCERT, the beauty of NCERT is you think that you have covered this, but they will frame a question from the second page and they will straight away clean bowl you in the examination hall. So you may have this perception that you know them. Still, I will earnestly request you to please go through these NCERTs at least 2-3 times, because they will still trap you. So there is no need to be sure about oneself that since we have been reading this NCERT since our school days, so we are enough. Nahi. You do this and you will realize the difference, how UPSC is lifting question from them. So these 4 NCERTs. Second, I'll be briefly talking about, then we'll immediately start because we have to discuss within the time frame that has been allotted. Okay. Next is newspaper. Okay. I am astounded with what you call alarming rate that time and again students are coming and they make the same request that can we skip newspaper? Can I take supplements like dry fruits and skip the main course? Can I only take the supplements and skip the main course? No. Newspapers are not about information. Believe me, newspapers are not, other than the editorial part. That gives you a very comprehensive insight into a particular topic. Otherwise, newspapers are not about information. There are only 150 or 200 words that a particular journalist is given to write on a particular topic, other than the what you call this 1000 or 1200 words of what you call editorial note. Newspaper में एक topic को, one topic is not comprehensively covered, but in 7-8 months or 1 year, when you consistently read newspaper, you will not even know that you have changed as an individual. Newspapers give you a broad horizon about the world. Newspapers give you an insight into the happenings. Newspapers make you an entirely different human being than what you were when you consistently read for 1 year, and you will not even get to know that you have changed. And the most important thing, newspapers let you know how to write a wonderful answer. So the art of writing answer also, you will gradually pick up terms that are consistently being used in newspaper. So it is not a factual thing. Kahan se factual hoga? If I am given 150 word to write something on page 1, I cannot sum up everything from 150 word. So as a journalist, you cannot write everything. But consistently, if you are reading a particular topic, then it intellectually makes you more rich about the understanding of that topic. And then of course, editorial is something which is a masterpiece. Okay. So second important thing, or ek aur baat. Things which are consistently appearing. There, I know one particular student who has been consistently scoring 140 in prelims. Of late, he has been scoring 120, 115 in these kind of papers. So although he couldn't, there are some issues with his optional, he couldn't qualify, but for prelims, he is very sure. One thing that the key, if anything is appearing in newspaper, for example, there was too many issues about payroll. For example, there were too many issues about prison. Consistently, last 2 years, we have witnessed so many things about prisons, people going to jail. So whenever a topic consistently appears in newspaper, you take internet and make a brief background reading on your own also. So anything that is consistently appearing in newspaper, ye aapki zimmedari hai. It is your responsibility to make a brief insight into that from your perspective also. Second important thing is newspaper. Third, any static source that you would be referring to. Just this is the last thing I want to discuss because I don't want to give much time to this. Static source. We know that we have M. Lakshmikant. Okay. You just go through the prelims question paper of last 2 years. And just go through what the UPSC is asking in prelims and mains. I don't need to even decipher that for you. You will be arriving at a conclusion on your own. Lakshmikant teaches you about secularism. And UPSC is asking what France can learn from Indian secularism. Lakshmikant lets you know about basic aspects of secular. And UPSC is asking, do you think our cultural practices are being challenged in the name of secularism? Lakshmikant teaches you about basic, what do you mean by a constitution or basic things? They are asking, a constitutional government is a prerequisite. Lakshmikant teaches you about a basic understanding of secularism. They are asking a conceptual fact. Lakshmikant is an excellent book to give you a broad, actually it is not an academic work, it is a notes. It is a wonderful notes where you will get an understanding of the facts, that this constitutional body, what is the function, what is the composition, and what are the, what you call other aspects, basic. What is the intellectual insight? What is the performance of that organization? What parliamentary standing committee says? What are the issues with that organization? What is the key areas or the issues surrounding that is not being covered? So over the period of time, Lakshmikant may be a wonderful book to give you a broad, very good understanding of the constitution, but I can say with uttermost honesty that it is not enough either for prelims and for mains. There would be 4 or 5 questions you will be able to answer. That is something which every book offers. So over the period of time, the relevancy of Lakshmikant to be suffice. Lakshmikant is not comprehensive or exhaustive in itself. It may be indicative, but not comprehensive or exhaustive. So you need to Vision. I must say with you go through Vision IAS printed material and you will be finding that things have been covered in a, not because I'm taking a session, honestly saying, things have been covered in a more comprehensive fashion. Just give half an hour and compare any topic. So any other source, whatever you are referring, you cannot solely rely on Lakshmikant anymore. And I don't know whether I'm sure or not, whether advertently, consciously Lakshmikant is being relegated by the commission. I don't know. That is something which is beyond my, I'm not no prophetic over that. But I don't know, Lakshmikant over the period of time has lost its relevance. It is wonderful to give you a solid background, but it is not enough to arrive at an answer, because over the period of time they are asking questions which have changed the dimension of the question. So you have to refer to any other book rather than solely relying on Lakshmikant. Okay, and one last thing before we start. 2 previous year's question paper are brilliant insight into the minds of UPSC. Like UPSC asked the question in Prelims 2017-16 that which of the following shall be referred to understand the minds of the makers of the constitution. 16 or 17, in fact, 17 Prelims they asked this question. Similarly, I would say which of the following is to be referred to understand the minds of UPSC, and that answer would be previous year's question paper. That is something which is going to let you. But from 2021, the dynamics have changed. So I cannot, when I go through 2013, 14, 15 prelims question paper, I arrive at a conclusion, kya poochte the? What they used to ask, what is the full form of Niti Aayog? Who takes a decision under 10th schedule? What do you mean by a constitutional government? Getting my point? What is, whether the term judicial review is mentioned or not, the term minority is not defined in the constitution. In order to get insight into the minds of the makers of constitution, which has to be, these were the questions that were asked. And see the questions that are being asked. Coal Control Order, a Prisons Act 1894, Official Secrets Act 1923. देखिए जलवा पूरा, the whole dynamics of the question has changed. So previous year's question paper are brilliant insight, but you should keep a brutal track on the happenings in newspaper, and whatever keeps on happening, make a brief search on your own also. You are being feeded with current affairs material, that is excellent, but a brief search on your own account also will do the justice. Now let's start with 2019. Okay, so now this question. So what I have done, we have taken, there are 4 sets, A, B, C and D. Whichever set I have taken, that is mentioned over here, okay? And second, the question number is also mentioned precisely. So that set D, it is question number 6. Why? Because what it will do is, when you will compare that with prelims answer key released by the stellar, the all, what you call powerful Article 315 Union Public Service Commission, Shahjahan Road, getting my point? So you can compare that, the official answer key meets, so that I have taken straight away refer to that. Okay, let's see, dear students. Which of the following statements are correct regarding Maternity Benefit Amendment Act 2017? Okay. When I was going through this 5 years, I found that there have been questions, 15% questions, which have been consistently repeated. Same questions, they have reframed the question, but the topics are being repeated. Okay, so we will not only, the purpose of the class is not to feed you with information, kiska answer ye hai, and tomorrow if they change, you will. The purpose of the class is, I'll try to holistically cover, holistically cover the entire what you call horizon of knowledge and information that can be deduced from that question, and you are free to ask any question. Any question you are free to ask. Okay, let's start. First of all, this question is about Maternity Benefit Act. I would rate this a very full toss question. This was the easiest question. Why? Because Maternity Benefit Act 1961 was amended in 2017, and this question was asked. So this was something which was asked directly from something that has been recently amended and have been discussed in the classroom umpteen number of times. Okay. First, maternity benefit. So we have socialist principles in directive principle of state policy. You know that. So we have socialist principle. What are the socialist principles? Article 38. Kya hai bhai? Welfare state, social, economic and political justice, minimizing inequalities in income and eliminating inequalities in status. Article 39, Article 39A, legal aid. Article 41, right to work. Article 42, just and humane conditions of work and maternity relief. So one thing, many a times you need a law to implement a provision of the constitution. I am again saying, कई बार constitution के, whenever I will speak in Hindi, I will undoubtedly repeat that in English. जब भी आप constitution के, कई constitution के ऐसे articles हैं जिनको implement करने के लिए एक law की जरूरत है. Many a times you need a law to implement a provision of the constitution. जैसे Article 17, Untouchability, Protection of Civil Rights Act, SC/ST, Prevention of Atrocities Act 1989, Article 23, Bonded Labor System Abolition Act, Immoral Trafficking Prevention Act, Article 24, Child and Adolescent Labor Prohibition and Regulation Act, Article 39A, the Legal Services Authorities Act, Article 42, Maternity Benefit Act 1961. So many a times you need a law to implement a provision of the constitution. So Article 21A, Right to Free and Compulsory Education Act 2009 is to implement Article 21A of the constitution. Similarly, उसी तरीके से, to implement Article 42 of the constitution, a law has been passed by the parliament that is called as Maternity Benefit Act 1961. So कई बार कॉन्स्टिट्यूशन के एक प्रोविजन को इंप्लीमेंट करने के लिए एक ऑर्डिनरी लॉ भी पास करना पड़ता है. Many times to implement a provision of the constitution, you have to make an ordinary law. Why? Because everything is not possible to be inserted in the constitution. So जैसे Article 11 of the constitution and entry 17 of the union list empowers the parliament to make laws related to citizenship. So in pursuant of entry 17 and Article 11, parliament has passed Citizenship Act 1955. So many a times you need an ordinary law to implement a provision of the constitution. उसी तरीके से to implement Article 42 of the constitution, a law has been passed by parliament, that is Maternity Benefit Act 1961. पहला. दूसरा, what an intelligent student will do, the moment I am making a mention of Maternity Benefit Act, an intelligent student will download the law. No need to go through all the sections. Even if you have law as an optional, at least you will go through the synopsis. Or if at the beginning of the law, Lokpal and Lokayukt Act, Right to Information Act, Mahatma Gandhi National Rural Employment Guarantee Act, Environmental Protection Act, all these laws you will find shuru mein they have given a reason why this law has been enacted. So the moment I mention this law, it is your paramount duty to download the law and at least go through if there is an objective of the law given at the beginning, or over the internet have the synopsis of the law. Now this is an easy question. It says, which of the following statements are correct regarding Maternity Benefit Amendment Act? Pregnant women are entitled for 3 months pre-delivery and 3 months post-delivery paid leave. This is factually incorrect. Okay, that is something. There is no such thing. With post-delivery, you can take up to 6 also. Altogether, you have to take 26 weeks. So this is a wrong statement. Enterprises with creches must allow mother minimum 6 creche visits. Although it is 4. An employer with more than 50 or more employees will need to have a creche, and it is 4. And this Maternity Benefit Act 1961 as amended in 2017, the mention is of 4. So this again is a wrong. So women with 2 children get reduced entitlement. Bilkul sahi. The 26 weeks benefits is available only for up to two living children. Even if the women had 3 children, but unfortunately 1 child died, then the 2 children, the second child will be counted as as 2 children. So up to 2 children, this benefit is of 26 weeks. Otherwise, there is a reduced benefit of 12. Okay, so this statement is a correct statement. But what is important for you, this I am not here to tell you that this is correct, this is available over internet also. What I am saying, you should go through Maternity Benefit Act. What are the amendments? Time and again they are asking question. Abhi main batata hu. Question pehla, do you think Right to Free and Compulsory Education Act 2009 has been able to incentivize school education in India? 2022 mains question. Do you think Right of Persons with Disabilities Act is able to achieve its mandate? A similar question. So of late they are asking question about not about the law, about the analysis, the what you call the synopsis, and how the law is being implemented. Yani wo ye, they don't want you to know all the sections. What they want you to know, there are 15-20 laws that I will give you at the end. They will be asking again how these laws are being implemented, what are the issues with respect to, fir puchenge mains mein. In prelims, they will be asking basic. I have already given 15-20 laws and repeatedly they are asking those laws. So 2 questions which have been asked last year only, I am bringing that to them. Do you think Right to Free and Compulsory Education Act 2009 is able to incentivize school education in India? Next time they will ask a question, do you think Maternity Benefit Act 1961 has been able to achieve its mandate? Discuss with critically analyze the law with suitable examples. So is tarike ka question bar, please understand this. Every exam has its own tenor, TENOR, has its own insight. If I ask what is Article 40, the entire world would say village, पंचायत. Article 40 is village. UPSC के बच्चे से ये पूछेगा. UPSC aspirant, they will ask what is Article 40. Article 40 says the state shall take steps to organize village panchayats and endow them with such powers so as to enable them to function as units of self-government. For UPSC, knowing that Article 40 is village panchayat is not even a relevant thing. That is expected you to know. The second part, empower them to function as units of self-government, is something which is important. They don't want you. So UPSC will not ask a question what is Article 40. UPSC will ask how Article 40 is critically. Jaise, for example, Article 21A. They asked a question on Right to Free and Compulsory Education Act. Jaise you have Article 50. Everyone will say what is Article 50? Tell me. What is Article 50? Separation of judiciary from executive. ठीक है, सबको मालूम है. Even a lower divisional clerk, SSC or any exam, they asking. Article 50 says the state shall take steps to separate judiciary from executive in the public services of the state. So how the separation of judiciary from executive is happening in the public services of the state, how the magisterial powers are taken away from civil servants, why it is necessary to achieve separation of powers, what is the exact language of Article 50, that is something which is expected from a civil services aspirant. Knowing that Article 40 is village panchayat, from mains perspective, it is not important unless you know what steps are being taken to empower the village panchayat to function as units of self-government. अब इस क्वेश्चन में the first statement is factually an incorrect statement. The second statement is 4. So again, this is a incorrect statement and this is a correct statement. So we will easily settle for option C for Calcutta, that is 3 only in question number 6. So question number 6 of 2019, we will settle for C for Calcutta. Now this is a wonderful question. They can be in context of any country. This question has been taken from class 11th NCERT book Sociology. This question has been taken from class 11th NCERT book Sociology. This question has been directly taken from that. Okay, let's now come to the question. In context of any country, which of the following would be considered as parts of its social capital? Okay, there can be an economic capital, wealth, there can be a cultural capital, there can be an educational capital, you are empowered with knowledge, social capital, social interactions, behaviors, how the society interacts and what is the level of harmony, how there is an interaction between social bond within the members of the society. And we have the fundamental duty, Article 51A, develop spirit of brotherhood, transcending religious and all boundaries. So this question has been taken from Sociology, National Council for Educational Research and Training, NCERT textbook. Now, even if you don't have any backing, you have not read that text, which honestly speaking is usually not recommended. For GS, that book is usually not recommended unless you have sociology as an optional. It is not. Then also we can arrive at a conclusion. Let's read the statements. The proportion of literates in the population. Do you think that a society being more educated will be social capital or it will be educational capital? It will be educational capital. The stock of its buildings, the moment you get the term buildings, that is economic capital. The size of population in the working group. Having population is working, 2013 prelims question. Which of the following India has to do to achieve demographic dividend? Every child knows that skill development is required to achieve the dividend out of demography. So having population in working age group is not pertinent unless it is empowered with requisite skill set. So we will eliminate this, the level of mutual trust and harmony in the society. So even with the kind of exposure, academic exposure that you have for civil services, you can easily, I can admit that in the examination hall, the things are not as cool as in Vision IAS classroom. Air condition is working, there is a water, getting my point. So it is a different level. But one thing you remember, anything is being asked is same for everyone. So you don't, UPSC wants you to panic. I don't want, but there are few questions which they have asked. For that you don't need any book. They have asked a question in science, you can travel from here to here without traveling into time and space. And if they give a big paragraph, it is most likely the easiest question in the examination hall. What they are doing, they are trying to test ki, has he not panicked in the... So whenever you see a big paragraph, in all likelihood, I cannot say with a parameter, but in all likelihood, it is an easy question just by framing a big... In Internet of Things, they asked a question. In 2016-17, they asked a question on Internet of Things. They gave a big paragraph. A very easy question, but that's question. You enter the your home, the light gets on, and then the television set, and but this was an easy question, Internet of Things. They asked a question which we will discuss. On Article 14, they gave a big paragraph, the most easy question. So here, even by you can conclude that social capital, first, this question has been taken from sociology and CERT text. Second, by reading at the statements only, you can arrive at a conclusion. Third important thing, social capital as a sense of brotherhood and fundamental duty, also it is pertinent. So we can easily settle for option D in question number 10. Okay. Let's see. Now this is an easy one again. Ab to bhai Sarkaria Commission. Sarkaria Commission, there are more than 250 recommendations. Of course, for a human mind devoid of artificial intelligence, it is not expected to remember to more than 250 recommendations. And it is equally important that if someone remembers more than 250 recommendations, then also he needs a treatment because he is deviating from the principal mandate of the UPSC. Okay, so both the sideways, but don't you think that office of governor is something which is perennially being a matter of contention between the center and the states, and the idea of federalism is being debated every single day? Don't you think that the NEET bill, don't you think related to the University Grant Commission, the judgment given by P. Srijit and Sri Kumar case, don't you think the judgment given where the appointment of APJ Abdul Kalam Technological University in Kerala Vice Chancellor was set off, don't you think that the preponement of the assembly session has been a bone of contention between Council of Ministers and the governor? Don't you think that with respect to the what you call dismissal of Chief Minister, recommendation of President rule, not approving the NEET bill with respect to the what you call acting on the aid and advice of Council of Ministers, giving warning that the pleasure with respect to appointment of minister can be withdrawn? Throughout the year, there have been an issue related to the office of governor. Still, if we are not prepared about the recommendations made with respect to governor, then something that is so even governor in the class also was taught as separately, president governor. Now governor is being taught in center-state relations because it is more important to understand governor from the perspective of center-state relations, which is purely a unitary feature. Let's see. Now, first Administrative Reform Commission, 1966. Okay, Moraji Desai initially was the chairman. Then when he became deputy prime minister, Hanumanthaiah became the chairman of first administrative reform commission. Second administrative reform commission, you have Virappa Moili ji. Okay. Next we have, of course, this was not the recommendation of first ARC. Next you have Raj Mannar committee set up by Tamil Nadu government. Among the recommendations given in M. Lakshmikant 6th edition, Tata McGraw Hill's. Okay, it is given. What are the recommendations? Abolition of all India services. Governor should be getting my point. Abolition of all India services, and this committee basically is related to federalism. Okay, but this was by a state government. Okay, so again, this is not an answer. National Commission to review the working of Constitution, also known as Justice Venkat Chalia Commission, who once famously said that the relationship between judiciary and executive should be correct, not cordial. The relationship between judiciary and executive should be correct, not cordial. As a judge, I am adjudicating upon the cases Keshavananda Bharti versus State of Kerala, Shreya Singhal versus Union of India, Supreme Court Advocate on Record Association, others versus Union of India, KS Puttuswamy versus Union of India. Getting my point? So SP Gupta versus, so the Union of, so most of the time judiciary is adjudicating where one side you have government and other side you have union, one side you have Union of India, other side you have a party. So the relationship between judiciary and executive should be correct, not cordial. That is why constitutionalism is the paramount basis. Abraham Lincoln ने क्या कहा? Nearly all men can stand adversity. बुरा वक्त तो सब झेल लेते हैं. Nearly all men can stand adversity. If you want to test a man's character, give him power. If you want to test a man's character, give him power. So constitutionalism is a prerequisite, and center state relation में federalism 11th March 1994 SR Bomai versus Union of India, federalism is the basic structure of the constitution. Keshavananda Bharti versus State of Kerala, federalism is the basic structure of the constitution. The use of term federal is avoided. The federal that we have adopted. What is center state? Up center state relation में तो it is a 15-hour topic. Legislative relation, executive relation, financial relation, the most interesting one. President rule, national emergency, financial emergency, interstate council, नीति आयोग, interstate water dispute, zonal council, और भी topics है ना बाबू, यही थोड़ी. Article 131 Supreme Court original exclusive jurisdiction to decide about dispute between center and state. Okay, so federalism में these days office of governor is in news. It was R.S. Sarkaria Commission, constituted in 83, submitted its report in 88, which made a recommendation that कह रहा है which of the following suggested that governor should be an eminent person from outside the state and should be a detached figure without intense political link or should have been taken part in the politics in recent past. So this recommendation was made by R.S. Sarkaria Commission on Center-State Relations. That is something which is very, very important. So question number 16 we will settle for option C for Calcutta. Ye commission, when Tamil Nadu mein, you know, federalism got a major, rise of regional parties in India. Rise of regional parties in India is reflection of the spirit of federalism and more inclusive. It is undoubtedly, when the national parties have failed to cater to the regionalist aspirations, then has been the rise of regional parties in India. Second important thing, the very rise of regional parties in India exhibits the accommodative nature of Indian constitution. The rise of regional parties in India exhibits the accommodative nature of Indian constitution. The rise of regional parties in India exhibits the cooperative federalism, and not cooperative, although Niti Aayog is or GST is a better example, but it reflects that regional aspirations can also have their own way. It was late 60s when series of governments in the state were formed of regional parties, and DMK Dravidra Monitra Kanzam was one of them. Later on you have All India Anna Dravidra Monitra Kanzam, they had AIADMK. So the moment the party comes to power, it constitutes this committee to look into center state relations, which inter alia, among the other recommendations, made a recommendation to abolish All India services, which is a unitary feature. So this is given in Lakshmikant also, but this was an easy question. Sarkaria Commission is the commission जिसने recommend किया था that governor should be from other state. So we will settle for 16C, that is Sarkaria Commission. Okay. Now we have this. Now again, in India, which of the following review the independent regulators in sectors like telecommunication, insurance, electricity, etc.? Okay. Now this question, so question number 16 we will be settling for C. Now see question number 19. अब समझते हैं. सबसे पहले बाबू, there are regulatory bodies. हर चीज के लिए there are regulatory bodies. For example, Advocates Act, Bar Council of India to regulate. Bar Council का क्या काम होगा? Regulate legal education in India. Recently, Delhi University has started 5-year LLB course. तो क्या लिखा है? In pursuance of the notification number XYZ issued by the Bar Council of India, the University of Delhi hereby is permitted to start 5-year LLB course. So who is the body that will regulate legal education in India? Bar Council of India. Dental Council of India. Chartered Accountancy, ICAI. Company Secretary, ICSI. University Grant Commission, Higher Education. Similarly, National Medical Commission, a statutory body for medical colleges. So हर के लिए you have अलग. Insurance Regulatory Development Authority. Banking, Reserve Bank of India. Okay, now let's come. कह रहा है, which of the following review the independent regulators in sectors like telecommunication, insurance, electricity, etc. Okay. अब सबसे पहले, the principal mandate, dear student, is that you tell me what is the mandate of Finance Commission. कौन नहीं जानता है? What is the mandate of Finance Commission? Article 280. पहला mandate क्या है? Distribution of net proceeds of taxes between center and states and among the states. यानी vertical devolution or horizontal. Second, to recommend principles that should govern grant in aid under Article 275. Third, suggest measures to augment the consolidated fund of state for better devolution of funds to PRIs and ULBs. है ना जी, add किया गया है. Third and fourth has been added. Fourth, any other matter referred by the president in the interest of sound public finance. So these are the four major mandates of the Finance Commission under Article 2. क्या है उसमें? Finance Commission is the balancing wheel of fiscal federalism. It has to make recommendations between center and state. It has made recommendations. 41% will go to center, 41% will go to state, 59% will go to center. ये ना उनका कहाँ से काम है कि regulate? Do you think they have a job to regulate insurance, electricity, telecommunication? बिल्कुल नहीं. So Finance Commission is a body by the founding mothers and fathers in the Constituent Assembly. It is a body envisaged to promote fiscal federalism in India. अभी वही बोल रहे हैं ना, each and every word used here, we will have 3-hour discussion on that. But I'm trying to restrict myself. Literally, we can have 3-hour discussion on every question. But we will try to restrict to but I'll try to give you the maximum. So Finance Commission, what is the principal reason on Finance Commission? The principal reason of Finance Commission is to promote fiscal federalism. Promote fiscal federalism. Tax के मामलों में, so which is more strong, center or state? Center has corporation tax, personal income tax. State has agriculture tax, cooperatives, fisheries. Getting my point? Or 5 things they have: aviation, turbine fuel, liquor for human consumption, petrol, commonly known as motor spirit in Constitution. You have crude petroleum and diesel. These are kept outside GST. Otherwise, states are garib. Okay, states are garib when it comes to fiscal. Ab you see US, you see United States. एक छोटा सा. So if you will see the economy of California. Okay, that is good. So it is economy of California. So it is like, so there you don't fiscal fed, it is what you call, okay. So by 4% it is some to $3.701 trillion. Bhai Saab, economy of one state. It is the UP of US. It has 53 members in US Lok Sabha, which is the highest. So So there you don't need a finance commission because states are not super garib. Here you have some states and you have some other states. So you need a finance commission and that is not a regulatory body. So अब ये मैं क्यों emphasize कर रहा हूं? Let's see. Let's delete finance commission. The moment we eliminate finance commission, we are left only with 1 and 2 and 2 and 5. So 2 is common. So we have to see whether 5 is correct or 1 is correct. यही ना देखना है जी. Either 5 is correct or 1 is correct. Let's see. So 5 is Niti Aayog. Niti Aayog constituted by a cabinet resolution 1st January 2015. It is an intellectual think tank. It has no regulatory or implementary mechanism. Article 282 discretionary grants. Also Niti Aayog has no role. It comes out with certain indexes. It has short term, medium term and long term plan. It has short term, medium term and long term plan. It releases certain indexes. तो कहां से इसमें telecommunication and regulation कहां से आ गया? So the moment you eliminate finance commission and Niti Aayog, let's eliminate 3 and 5. You have 1 and 2. You have 1 and 2. That is the correct answer. ऐसे भी सालों भर throughout the year you read in newspaper. I don't want to open. I told you now we can take 3 hours on each question. Okay. If throughout the year you will read question, department related standing committee made phala recommendation, department related standing committee made X recommendation. Let's see briefly. So DRSCs हैं, ठीक है. There are how many DRSCs? 24. 16 under Lok Sabha and 8 under Rajya Sabha. Maximum up to 31 members are there. 21 LS 10 right hand side. Just kidding. So the point is 21 Lok Sabha 10. What are the 4 functions of DRSC? Pehla, to look into the demands for grants. Second function is to look into the bills. Third, यही लिखा हुआ line से. Third is look into long-term policy statements. And fourth is annual reports. So let's come to the question. Now let's come to this very important question. अब question पूछ रहा है which of the following reviews the independent regulators? So it is department related standing committees and other ad hoc committees that time to time make a अभी जैसे DRSC in January made recommendations for CBI. DRSC made recommendation related to, ये नहीं बताइएगा तो I'll be very upset. DRSC made recommendations related to UPSC that the exam should be, the entire bracket of exam should be completed in 6 months. क्या है ये? कौन है ये लोग? So the point is, so you are getting my point now. So we have such wonderful recommendations coming from honorable members of parliament through DRSC. So throughout the year DRSC making a recommendation on CBI, DRSC making a, अभी मैं पिछले 1 साल का बता रहा हूँ जो मेंस में they can ask. DRSC making a recommendation on UPSC, DRSC making a recommendation on Indus Water Treaty, DRSC making a recommendation on CBI, DRSC making a recommendation on fiscal prudence to be and populist measures, all these things. So time and again department related standing committees are making recommendations to the government. उसी में ये सारे regulatory bodies भी हैं. So I can very safely conclude that the first and second are, and what is an ad hoc committee? Ad hoc मतलब Joint Parliamentary Committee on 2G scam, Joint Parliamentary Committee on stock market scam. So एक काम ad hoc means temporary. So we can easily exclude 3 and 5. By excluding 3 and 5, we are getting an answer that is 1 and 2. याद रखिए, in last 5-7 years, after every year they have asked a question on department related standing committee. Mains में, prelims में कम, mains में ज्यादा. DRSC से क्वेश्चन ना आए ऐसा हो ही नहीं सकता है. He says ना तुम मुझे भूल जाओ ये so मैं तुम्हें भूल जाऊं ये हो ही नहीं सकता, तुम मुझे भूल जाओ ये मैं होने दूंगा. So UPSC ना पूछे ऐसा हो ही नहीं सकता है. So department related standing committee making recommendations on CBI, on UPSC, on other aspects are brutally important. I am not, if you know about 24 committees, 31 members, 21 Lok Sabha, 10 Rajya Sabha, they are not elected directly by the speaker and the chairman. ये सब मुझे कोई खुशी नहीं होगी. They came into force in 1993, 2004 तक 17 committees were there. It was increased to 24. ये सब आता है तो ठीक है. ये आता है तो मतलब यू आर एलिजिबल टू फिल द फॉर्म. गेटिंग माई पॉइंट. ऐसा मुझे कोई खुशी नहीं होगी इससे. दीज आर बेसिक फैक्ट्स दैट यू नो, बट आई एम नॉट कंसर्न. एवरी in December or January Vision IAS current affairs, down the line you will see recommendations made by DRSC on CBI. Those questions can be asked by UPSC mains also. So you tell me what should be. We are eliminating 3 and 5. We are conveniently concluding on 1 and 2. So बाबू 19 का आंसर होगा A, that is 1 and 2. क्वेश्चन भी पूछ सकते हैं, कोई बात नहीं है. वोकल कॉर्ड्स क्यों दिए गए हैं? ओके. Now with reference to the Constitution of India. So Constitution of India, Article 393 of the Constitution. This Constitution may be called Constitution of India. There is one article which has done namankaran. Article 393 says nothing, bas one line. This Constitution may be called as Constitution of India. ताकि कोई Getting my point. So इसीलिए एक आर्टिकल है जिसमें सिर्फ नामांकन है. This constitution may be called Constitution of India. Okay. So, huh? Why? Why? Because the point is कि there, for example, sometimes the people may call the fundamental law of the land. Sometimes the apex court in its obiter dicta may say the principal document running the nation. Sometimes they say a document that reflects the ideology and philosophy of the nation. So that is why they don't restrict the use of term, but the official term would be if you read the debates. I don't want to go into the debate of Constituent Assembly, पर अभी दूसरा एक मतलब ट्रेन गोरखपुर की बजाय कहीं और, so I don't, but this is anyways coming here. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Article 226A of the Constitution. डाला, delete कर दिया. Inserted and later deleted by 43rd Constitutional Amendment Act. कहानी समझते हैं. In 226A there is a provision. High Court cannot examine the constitutionality of a law passed by Parliament. This was a provision in the Constitution. This was. So can the High Court, there is a common confusion among students. Can the High Court declare a law passed by Parliament as unconstitutional? Yes. Example, 97 Constitutional Amendment Act 2011, as I discussed in the class also, Gujarat High Court declared that as unconstitutional, the matter went to Supreme Court. Generally, a law passed by Parliament is only challenged in Supreme Court. I am using the term generally. L. Chandra Kumar case 1997, Supreme Court sets the power of High Court to exercise judicial review under Article 226 is the basic structure of the Constitution. So a law passed by Parliament can also be constitutionally reviewed by the High Court. First point. Second important thing, under Article 226A of the Constitution, the High Courts were prohibited from exercising judicial review over the law passed by Parliament. The same has been done away with. So ab High Court can examine the constitutionality of a law passed by Parliament also. Let's see now. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. True or false? False. High Court can declare a parliamentary law as unconstitutional. Okay. An amendment to the Constitution cannot be called into question by the Supreme Court of India. क्या होगा? This is also a false statement. क्यों? Reason दिया है. Knowing basic structure is ठीक है, अच्छी बात है. Basic structure. But what the reason Supreme Court gave for basic structure, you should know that, and you should write that in your answer. Supreme Court ने basic structure judgment is kept in Supreme Court Museum. The Keshwananda Bharati judgment is kept in Supreme Court Museum. क्या reason दिया Supreme Court ने? So an amendment to the Constitution cannot be called into question is a wrong statement. An amendment to the Constitution can be called into question. Classic example, 99th Constitutional Amendment Act was declared unconstitutional in October 2015 in Supreme Court Advocates on Record Association and Others versus Union of India. What 99th Constitutional Amendment did? उसमें क्या था जी? ऐसे थोड़ी, यूपीएससी का बच्चा ऐसे थोड़ी अपॉइंटमेंट कॉलेजियम, ये तो जो एवरीवन हु व्हाट्सएप यूनिवर्सिटी को भी आता, अच्छा कुछ चल रहा है कॉलेजियम है, he will also say precisely it added article 124A Tab you will wait for the UPSC to ask the question and then you will know that. There was a person who was asked that you never make mistakes. Why? He said, I learn from the mistakes done by people whom I advised. I learn from the mistakes done by people whom I advised. So it is wise to learn from others. Now you will wait for the UPSC to critically examine the NJAC judgment has been, the petition has been filed to review that. Now you are waiting for UPSC to ask that question. एक एग्जाम्पल देता हूं, बिना चटनी गिराए तो समझ में नहीं आएगा ना, एग्जाम्पल देना तो बहुत जरूरी है. 4 महीने पहले the constitutionality of first constitutional amendment act was challenged in Supreme Court. Constitutionality of first constitutional amendment act 1951. पूछ दिया prelims में. Answer is first. Why that question was asked? Because it was in current affairs. The 99th Constitutional Amendment Act, which was struck down by Supreme Court, that case has been filed in Supreme Court to review that. So now UPSC will ask a question, discuss the critically examine the 99th Constitutional Amendment Act, and then somebody sitting next to you will clearly write in a very small way 124A, B and C, and you will write collegium, transfer, posting, getting, and then you will say marks nahi aa rahe. So the point is, you should precisely know what you should know less, but whatever you know, you should be absolutely clear that what is the language of Article 40, Article 50, Article 21A, Article 42, Article 38. कम ही जानिए, पर जो जानिए सॉलिड जानिए. एकदम सही शब्द का इस्तेमाल किया आपने. So now listen. 99 Constitutional Amendment Act. 99 Constitutional Amendment Act. This question I think they may ask this year also in mains. 99th Constitutional Amendment Act amended Article 124 and 217. It amended Article 124 and 217 and added 3 new articles. 124A, B and C. What is Article 124A? Composition of NJAC. What is Article 124B? Function of NJAC. What is Article 124C? Parliament will make a law regulating the appointment. So Parliament को power दिया गया कि it will make a law. Can you give some example where Parliament only has the power to make laws, not the state legislature? जल्दी दीजिए. Article 35 of the Constitution क्या कहता है? Anything that is an offense in fundamental right, law will be made by Parliament, not the state legislature. ये लिखा हुआ है, it is written in Article 35 कि anything that has been made offense in fundamental rights, the law will be made by Parliament, not by the state. Example, what is an offense in fundamental rights? Untouchability, child labor. You have Child and Adolescent Labor Prohibition and Regulation Act, immoral trafficking. Getting my? So anything that is an offense in fundamental right, law will be enacted by Parliament, not the state legislature. ये तो मैंने contribute किया भंडारे में. This I contribute. You also contribute some. You also. Article fundamental rights, Babu. 12 to 35. Article 11 is part 2 citizenship. Yes, बिल्कुल. Entry 17 बोलने की भी जरूरत नहीं. Entry 17 of Union List is citizenship. I am talking about fundamental rights. I am not talking about part 2. Article 34. Parliament may by law indemnify the act done by a servant who is the employee of the union or the state or any other person where martial law is in force. Article 33. Parliament may restrict the fundamental rights of armed forces in connection with intelligence, counterintelligence for proper discharge of their duties and maintenance of discipline. So under Article 33 and 34, law will be made by the Parliament, not by the state legislature. This is written in Article 35. एक example अभी भी छूट रहा है. Article Parliament may by law extend the jurisdiction of any court to exercise writ jurisdiction other than Supreme Court and High Court. और कुछ अभी भी एक छूट रहा है. आर्टिकल पार्लियामेंट नहीं लिखा है. आर्टिकल 16 clause 3. Parliament can prescribe residence as a criteria for certain classes of employment within the state or union territory for residents of that state or union territory. So ये article 35 में लिखा हुआ है. It is mentioned in article 35 that article 16 clause 3, article 32, article 33, article 34 law will be made by the Parliament, not by the state legislature. Okay, coming back to this. That is why I don't want to deviate, otherwise it will be like, so it says no high court shall have the jurisdiction to declare any central law. This is a wrong statement because Article 226A has been repealed. An amendment to the constitution cannot be called into question in Supreme Court. Any amendment to the constitution can be called to Supreme Court. So both the statements are wrong. So we will settle for D for Delhi. So question number 21 का answer होगा D for Delhi. Okay, please. Originally, अच्छा सुनिए, भाई ने एक सवाल पूछा, why Article 226A was repealed? The moment you see A, it is an insertion letter. जैसे, whenever you see A in capital letter in the Constitution, it is an amendment letter. Article 21A, Article 39A, Article 43A, Article 48A, environmental. Article 51A, Article 323A, याद है ना, एडमिनिस्ट्रेटिव ट्रिब्यूनल, आर्टिकल 350A, चिल्ड्रन ऑफ लिंग्विस्टिक minorities, article 226A. So whenever you find A in the constitution, it means that it was not there in the original constitution, it has been added later. So 226A was added and later on it was repealed. Okay, so both the statements are wrong and we will settle for 21 ka D. Okay, now let's see 25. This is my favorite question till now. This question was taken from political theory book. Okay, this is pure conceptual question. It has no fact in it. It is purely a conceptual question. Okay, time ki bhi baat hai. In context of polity, which of the following would you accept as the most appropriate definition of liberty? What you think should be the answer? D for Delhi. Okay, this I have discussed in the class. Many times the answer was given absence of restraint. Why absence of restraint should not be the answer? What is liberty? Liberty is responsible use of freedom. Responsible use of freedom under rule of law. Liberty is responsible use of freedom under. Liberty does not mean absence. Now imagine liberty means absence of restraint. But there is only one word that is lacking here. If one word I will add, this statement B will become correct. Absence of unnecessary restraint. Or article 19(2) की language put करे तो reasonable restraint. If there is absence of restraint in the society, what will happen? I will move out, kill someone. X person will go and slap someone. Why are you wearing red shirt or blue shirt? X person will go play loud music. So in a society there should be absence of unnecessary restraint. No society can exist without absence of restraint. So restraint is necessary. Only unnecessary restraint should not be there. Ab liberty kya hai? Responsible use of freedom under rule of law. Liberty does not mean license to do whatever. Liberty means maximum expression of human manifestation. इंसान का maximum expression, how to develop. This is the work of Amartya Sen. And this question has been taken from class 11th political theory book. So we will easily settle for option D for Delhi. Liberty का मतलब है इंसान को ऐसी सहूलियत दी जाए, positive liberty, I'm not talking about negative, कि वो अपने को maximum विकास करे. The human mind should be given maximum opportunity to promote themselves. That is liberty. What is important from that perspective is that state must interfere in those matters. Dadabhai Naoroji once said in his book that poverty and un-British rule in India, there was a thing that Britishers used to say that there is so much law and order is so good in the country. Britishers कह रहे थे कि we have brought law and order, Indian Penal Code, Criminal Procedure Code, इससे पहले कभी नहीं था. So Dadabhai Naoroji said yes, there is a law and order, maybe it has bettered. But poor man is allowed to starve in peace. Poor man is allowed to starve in peace. You may have a very good public order, but the state is not taking care of the poor. So everyone should be given opportunity to develop oneself is also a form of positive liberty. Liberty does not mean that there will be no restraint. लिबर्टी का ये मतलब नहीं है कि रिस्ट्रेंट नहीं होगा, लिबर्टी का ये मतलब है कि अननेसेसरी रिस्ट्रेंट नहीं होगा, नेसेसरी रिस्ट्रेंट होगा। गेटिंग माय पॉइंट? नेसेसरी रिस्ट्रेंट मींस कि इफ देयर इज नो रिस्ट्रेंट इन द सोसाइटी, एनीबडी विल किल एनीवन, सो देयर शुड बी नेसेसरी रिस्ट्रेंट, देयर शुड नॉट बी unnecessary restraint. There should be unnecessary restraint should not be there. Or initially the concept was negative liberty, that state must not interfere. पहले concept था negative liberty, अब concept है negative as well as positive. State must not interfere in both some things, but in many things state should actually interfere and raise the level of standard. So liberty is positive also and liberty is negative. Negative liberty means absence of unnecessary restraint. Positive liberty means develop oneself fully. State will provide an opportunity to develop oneself fully. So in question number 25 we will settle for D for Delhi. Okay. अब इसके लिए I would strongly recommend go and go through the NCERT book of class 11, that is political theory. Okay. Now पहले, सबसे पहले it was called primitive tribal group. In 2006 name has been changed to particularly vulnerable tribal group. पहला. Second, in 2023 budget a new scheme has been announced. Pradhan Mantri, there is a special scheme for particularly vulnerable tribal group, so you should go through that scheme. Third, Eklavya schools में a new contribution is being made, so that is also important from the perspective of 2023 budget. Next, coming to this, कह रहा है particularly vulnerable tribal groups. अब चूंकि we are talking, dear students, let's discuss few more things also, ठीक है, because I know those things you are lacking. Okay, सबसे पहले let's discuss article 339, article 340, because it has, the question has a relation. Article 338A B. Okay, now listen to me, this is very very important. And then we have article 338. Okay, so article 339 गौर से सुनिए. सबसे पहले article 338 is National Commission for Scheduled Caste. Article 338A is National Commission for Scheduled Tribe, and article 338B is National Commission for Backward Classes. So you have three commission: NCSC, NCST and NCBC. So National Commission for Scheduled Caste, Scheduled Tribe and Backward Classes. Now these are permanent commissions. These are permanent commissions which function throughout the year. But there are two more commissions which UPSC can ask in prelims as well as mains. Article 339, President can constitute a tribal commission. गौर से सुनिए. President can constitute a tribal commission to make recommendations for the well-being of the tribals in scheduled areas and in general for the well-being of the tribal. एक बात. दूसरी बात, the first such commission will be established 10 years after the commencement of the constitution. It is compulsory for the president to constitute one first such commission 10 years after the commencement of the constitution. यानी constitution जब बना उसके 10 साल बाद पहला commission बनाना जरूरी है. After that, president can constitute any time. So first commission was constituted in 1960, UN Debhar Commission, and second commission in 2002, Dilip Singh Bhuria Commission. So first, you will never get confused between these commissions under Article 339 for tribal. This is a temporary commission. This is a permanent commission. So newspapers, many times they use a commission under 339 and a commission under 338A. 338A एक permanent commission है which generally functions. 339 is a temporary commission. Constitution says one commission has to be constituted 10 years after the commencement of constitution. So पहला commission was constituted in 1960. After that only. So how many commissions have been constituted? 2. And backward classes commission, we all know that is Kalekar Commission, BP, Mandal Commission and Justice G. Rohini Commission. So the backward classes commission in Article 340 and the tribal commission in Article 339 are different from the permanent commissions under 338, 338A and 338B. They are permanent commissions. These are temporary commissions which is constituted with a particular task. After they complete their task, these commissions are dissolved. So, सबसे पहले, what is the, how many commissions have been constituted under 339 till date? Only 2. And how many commissions have been constituted under 340? It is 3. Why I am saying this? Primitive tribal groups concept was introduced on the recommendation of first tribal commission constituted under Article 339, that is UN Debhar Commission. Now coming back to the question. Okay, it says primitive tribal groups in 18 states and 1 union territory. A stagnant or declining population is one of the criteria for determining PVTG. This is something which is correct. Yahan 95 is wrong, it is 75. And this is also correct. So you have 2 and 3 correct. Okay, now we will go and see which is the, this also is a correct statement. So we have 1, 2 and 4. So this is 1, 2 and 4. We will settle for option C for Calcutta, because this is a wrong statement. So we'll eliminate this and this is. एक काम और करना है, इस साल बजट में जो primitive tribal, particularly vulnerable tribal groups को लेके जो भी provision है, they can ask next year in prelims also. Okay, I'll give you an example. Maternity Benefit Act was amended in 2017. Question was asked in 2019. So we cannot say that the questions would be only from that year. Okay. Now let's see this with reference to the Constitution of India. Now Article 142. See, what is the concept behind Article 142? Simple concept. What is the jurisprudence behind Article 142? Supreme Court has various jurisdiction. Supreme Court has various jurisdiction. क्या क्या है भाई? You have Article 32, writ jurisdiction. You have Article 131, dispute between center and state, not union territory. Delhi versus central government, first judgment was given by Delhi High Court. Then the matter went to Supreme Court way back, 6 years back. So Article 131. Article 132 is appellate jurisdiction on constitutional matter, 133 is appellate jurisdiction on civil matter, and 134 appellate jurisdiction on criminal matter. 136 is a special leave petition. 143 is advisory jurisdiction. अब बचा क्या? 142. क्यों 142? If you read the debates of Constituent Assembly, why 140? For example, I'll give you a live situation. Many a times law is not enough to do justice. जैसे, I'll give you a reason. There is a Government of India program that if the girl child is only girl child, I'm just giving you an example, If the girl is the only girl child of the parent, then she will be given priority in admission in Kendriya Vidyalaya. Now somebody said to me, he was given to investigate some civil servant. What happened? There is a girl whose father died and she was abandoned by her mother. So she was being taken care by her grandfather, because father had died and mother had married someone else, so she has abandoned her girl child. Now she made an application for Kendriya Vidyalaya under that quota or Jawahar Navodaya Vidyalaya, anything. And that quota says ki bhai, you should be the only girl child of your mother. So that is the thing, parents. But her mother married someone else, with that she has 1 or 2 children. So now she made an application to be admitted under that quota. Somebody complained that no, she is not the only girl child because her mother also has other girl child with the next marriage. Now don't you think law here is not able to do complete justice? Now law says that she will not be admitted. Not law, the rule of the government says she will not be admitted because she is not the only. So कई बार ऐसा होता है कि कानून इंसाफ करने के लिए काफी नहीं होता है. So one beautiful word that have been inserted by the founding mothers and fathers in the Constituent Assembly, complete justice. So whenever the Supreme Court feels, I'll give you zillion examples where Supreme Court has used Article 142. Pehla, in the killers of Rajiv Gandhi case, 30 years Perari Valan was in jail, so he was released. Supreme Court mentioned that we are using powers under 142. A Lokayukt was appointed in one state. Supreme Court used powers under 142 because the state was not appointing. In what you call Ayodhya dispute, the provisions of 142 were invoked. And most important, in Union Carbide case, Bhopal gas tragedy, the provisions of 142 was imposed, and those people who died, their family members were given compensation. यानी 142 एक ऐसा आर्टिकल है कॉन्स्टिट्यूशन में, it is one article in the constitution where whenever the Supreme Court feels that law is not enough to do justice, they will invoke that article and complete the. कई बार कानून इंसाफ करने के लिए काफी नहीं होता है. So this is a special power which is given to Supreme Court where they can do complete justice. अब इसका मेंस में एक क्वेश्चन आ सकता है, that do you think that Article 142 leads to judicial overreach or judicial adventurism or judicial activism? You have to use that in a very balanced manner. अब देखते हैं. अब now you answer me. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as limitations on the constitutional provisions under 142. So law may not be a limitation under 140. कई बार law से इंसाफ नहीं हो सकता है, तब सुप्रीम कोर्ट इन्वोक करेगा 142. Now you tell me what should be the answer. I want you to answer. The decision taken by Election Commission of India while discharging its duties cannot be challenged in court of law. Can Election Commission of India be immune from judicial review? S. Subramaniam Swamy case 1996, Supreme Election Commission of India acting over any such thing acts as a quasi-judicial body. So definitely any body under the sun will also come under. कोई भी अपने को जुडिशियल रिव्यू से इम्यून नहीं. सिर्फ कॉन्स्टिट्यूशन में दो ऐसी जगह है. There are only two provisions in the constitution where the original constitution exempts judicial review. Can you say those two provisions? Article 329. Article, no law related to delimitation shall be called into question in any court. Any order or any law related to दूसरा, Article 262. In interstate water dispute, Parliament can exclude the jurisdiction of any court, including that of Supreme Court. These are the only two provisions from Article 1 to Article 395 where judicial review has been exempted by the original constitution. Otherwise, be it Indira Gandhi case, be it Minerva Mills case, be it Vaman Rao case, be it Air Coelho case, time and again Supreme Court has said judicial review is the basic structure of the constitution. Can Election Commission of India be exempted from judicial review? No. Statement कह रहा है कि the decisions taken by ECI while discharging their duties cannot be challenged in any court of law. Is it true or false? ये ट्रू है या फॉल्स है? फॉल्स है, क्योंकि ये इलेक्शन कमीशन को इम्यून कर रहा है जुडिशियल रिव्यू से. क्या इलेक्शन कमीशन जुडिशियल रिव्यू से इम्यून है? नहीं है. Getting my point now? Can the actions of election commission be challenged in Supreme Court? Can the actions of election commission be challenged in Supreme Court? Yes. So this is a wrong or a correct statement? This is a wrong statement. आगे देखते हैं. The Supreme Court of India is not restricted, constrained, inhibited, stifled, limited in exercise of its powers by laws made by. Whether this will be a correct option or a wrong option, this will be the correct option. आगे क्या रहा है? Financial crisis. Article 142 has nothing to do with financial crisis. State legislature cannot make concurrence. Article 142 has nothing to do with state legislation. Recently क्या हुआ? The killers of Rajiv Gandhi were in jail since way back on 21st May 1991. Rajiv Gandhi ji was unfortunately assassinated. So after that they were in jail. कई 30 साल से जेल में थे. Now the Supreme Court used its special powers under Article 142 and released them. क्यों भाई? अब उस पे मैं नहीं जाना चाहता. Because there is Article 72 and 161 dealing with pardoning powers. Then we have 432 section 4, जरूर पढ़िएगा क्योंकि बिल्किस बानो का केस चल रहा है. They are going to ask you in mains section 432 of CRPC, section 435 of CRPC and section 432A. Getting my point? So these are the क्या है, the state will make rules related to remission. Okay. That is then 435 central will be consulted and A. So there are बिल्किस बानो केस में CRPC एनीवेज. यहां क्या पूछ रहा है, क्या सुप्रीम कोर्ट को पार्लियामेंट का कोई लॉ रेस्ट्रिक्ट कर सकता है? नहीं. कैन सुप्रीम कोर्ट बी रेस्ट्रिक्टेड बाय अ लॉ पास बाय पार्लियामेंट? मेनी टाइम्स लॉ इज नॉट एनफ टू डू जस्टिस, देन सुप्रीम कोर्ट विल इन्वोक 142. एक और एग्जांपल. इन वन स्टेट, लोकायुक्त was to be appointed in discussion with Chief Justice of High Court, Chief Minister and Leader of Opposition. Leader of Opposition, Chief Minister and Chief Justice of High Court. तीनों किसी नाम पे राजी ही नहीं हो रहे थे. All three of them were not agreeable for one. Supreme Court went ahead and appointed Lokayukt using powers under 142. So Supreme Court को शक्ति है कि वो 142 का यूज करके वो काम कर सकता है जो लॉ में नहीं लिखा है, अगर ऐसा करना जरूरी है कंप्लीट जस्टिस. सो द सुप्रीम कोर्ट अंडर आर्टिकल 142 कैन डू एनीथिंग टू डू कंप्लीट जस्टिस व्हेन द सेम इज नॉट सैंक्शन्ड बाय द लॉ एक्सप्लिसिटली. That is 142. There can be a mains question on 142. Okay. So what should be the answer? I want you to say. What should be the answer? B. The Supreme Court of India is not restricted in exercise of its powers by laws made by the Parliament. Now let's come to this. With reference to the Legislative Assembly of a state, consider the following statements, okay? The governor makes a customary address to members of the house at the commencement of first session of every year. क्या ये correct है या wrong है? हर first session of every year, the governor will address the state legislature and Article 87 of the Constitution. 87 of the Constitution क्या है? President will address the first session of every year and first session when a new Lok Sabha is constituted. So ये statement बिल्कुल correct. Governor makes a customary address to members of the house at the commencement of first session. Okay. When a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on it. This is also a correct statement. So we will settle for option C for Calcutta in question number 33. This is something which is there. Okay, let's see. Now this is a brutally factual question. Okay, this question actually was asked from current affairs. This question was relevant that year, but is not perennially relevant. You know perennial and ephemeral. This is not perennial. Judicial review, collegium, fundamental rights are perennially important. But this question was important क्योंकि ये उस साल का. This was current affairs of that year. ठीक है? Although this is purely a factual question. Says United Nations, so इसके लिए we'll settle for C. United Nations Convention Against Corruption has a protocol against smuggling of migrants by land, sea and air. Actually, ये इस protocol में है. United Nations Convention Against Transnational Organized Crime. So इस protocol के statement को इस protocol में डाला है. So actually the statement is correct for this protocol. So this is a wrong statement. The UNSC is first ever legally binding anti-corruption instrument. Absolutely correct. A highlight of United Nations Convention Against Transnational is including, ये कह रहा है aimed at returning assets to their rightful owners. ऐसा कोई provision इसमें नहीं है. So this is also a wrong statement and this is a correct statement. Purely factual है. How you will get these questions correct? This question was asked from current affairs of that year. So ये statement wrong है. This statement is wrong, while second and fourth statements are correct. So we can settle for option C for Calcutta. Okay. Now this is right to marry someone. सीधा UPSC ने एक judgment दिया शफी जहां versus अशोकन. Supreme Court ने एक judgment दिया शफी जहां versus अशोकन. सीधा Supreme Court in Hadia case, popularly known as Hadia case, Supreme Court said right to marry someone is a part of Article 21. Right to marry someone is a part of Article 21. Shafi versus Ashokan judgment of Supreme Court, and UPSC asked the question, which article of the Constitution safeguards one's right to marry someone? That is Article 21. अब आर्टिकल 21 में 21 is enough for 2 years to discuss. Hussain Ara Khatun versus State of Bihar, right to speedy trial. Case Puttu-Swamy versus Union of India, right to privacy. Kiran Bedi case, right to reputation. Polluter pays principle, Vellore Citizens Welfare Forum case, right against sexual harassment, Vishaka guidelines. Getting my point now? So many, MC Mehta versus Union of India, MC Mehta versus Kamal Nath, series of cases, right to environment. So common cause versus Union of India, right to die with dignity. So Article 21 itself is an ocean. इसी में एक केस है शफी जहां वर्सेस अशोकन, वेयर द सुप्रीम कोर्ट रूल्ड दैट राइट टू मैरी समवन इज अ पार्ट ऑफ राइट टू लाइफ. ऑफ कोर्स द अदर पर्सन शुड आल्सो बी एग्री. ये नहीं कि खुश हो गया कि अरे ऐसा, मतलब द अदर पर्सन शुड आल्सो बी. सो विच आर्टिकल ऑफ द कॉन्स्टिट्यूशन सेफगार्ड्स वन राइट टू मैरी अ पर्सन ऑफ वन चॉइस? इट इज आर्टिकल 21. पर दोनों तरफ से भी राजी होना चाहिए. So I was discussing Navtej Johar or Joseph Shine case, as some of them are started laughing. But yeah, as a civil servant you will be facing these things when they will ask you these questions. कुछ और पूछे, मुझे तो इसमें थोड़ी सी शर्म आती. दूसरा क्वेश्चन भाई, if they any question getting so as a civil servant you should be open to ideas, and they may ask you a question and you will not say कुछ और ही तो बना किया मम्मी ने, मैं नहीं डिस्कस करूं. So that is basic, you must be able to. So you are part of the society, responsible. Yesterday I said that in cigarette the tax is levied as per length. We were discussing financial relations between center and state, GST council, direct taxes, indirect taxes. Taxes levies, so हंसने लगा. As a civil servant you may be sitting in Department of Economic Affairs responsible for budget. So आप थोड़ी बनी ये सब फाइल तो मना किया मम्मी ने, so तो इसीलिए you have to be more okay. Anyways, now let's see, dear students, consider the following statements. The 44th amendment to the constitution introduced an article placing the election of president, prime minister beyond judicial review. कुछ जानने की जरूरत नहीं है. Although this is 39th amendment, even if you don't know 39th amendment, you know that 44th amendment was to undo everything that was done by during the emergency. So why will the Morarji Desai government pass a law to exclude judicial review? क्योंकि 44th amendment आया ही था 42nd को. So और बहुत सी गलतियों को, so the mere purpose of 44th amendment was to undo. The 39th amendment exempted judicial review, Article 229A and other aspects, but you don't even need to know that. 44th amendment was to expand the power of judicial review if there can be a reason over that, not to restrict. So even if you don't know, you know 44th amendment was by Morarji Desai government, so this statement is a wrong statement. Next is, the Supreme Court of India struck down 99 Constitutional Amendment Act as being violative of the independence of judiciary. So this statement is a correct statement. We will settle for B2 only. Okay, now this is also an easy. So in question number 85, in 36 we will be settling for Article 21 in because of that Shafi Jahan case. Then we have 85, we will be settling for option B for Bombay, because the first is wrong while the second is correct. Let's see question number 86. Okay. Consider the following statements. Now, we will take all your questions also after this. We'll stop a bit briefly. Okay, I know. So now please understand. First of all, what is the difference between impeachment and removal? UPSC in its question has used the term impeach. Technically, you must be aware that the Constitution of India never uses the term impeach for anybody other than president. That you know. I know that you know, and you know that I know that you know. ठीक है? You know that I know that you know. But that is not my question. What is the fundamental distinction between the use of term impeachment and removal? क्यों term impeachment सिर्फ president के लिए use होता है और बाकी सब के लिए removal, judges के लिए removal? क्यों? ये ज़्यादा ज़रूरी है. ठीक है, what are the possible reasons given by the scholars? पहला, The term impeachment is always for violation of the fundamental law or the constitution. Impeachment term tab hoga for violation of the constitution. Precedent is used for violation of the constitution, while others are removed, judges are removed for proved misbehavior or incapacity. Yani, what is the ground to, we'll come to this question, don't worry. What is the ground to impeach the president? It is violation of the constitution. What is the ground to remove judge? Proved misbehavior or incapacity. पहला. दूसरा अंतर, impeachment, the process is also given in the constitution and the majority is also given in the constitution. In impeachment, the process is also given in the constitution and majority is also given in the constitution. So in case of president, the process is given in the constitution and majority. In case of judges, the process is given in Judges Inquiries Act 1968, majority is given in the constitution. So impeachment mein the process is also given in the constitution and the whole process of impeachment is also given in the constitution and the majority is also given in the constitution. In judges, process is not given. Process is given in Judges Inquiries Act. Majority is given in the constitution. President के केस में process of impeachment भी constitution में दिया गया है और majority भी constitution में दिया गया है. Third, when the parliament passes the impeachment motion against a judge, now who will remove him? Parliament will pass the motion and the president will issue an order of removal. There is nobody above president to remove him. The moment motion is passed by the parliament, president stands impeached. So what are the three possible reasons why they use the term impeachment only for the president and they use the term removal for the judges? Although UPSC has used this term, UPSC is like, leave aside. Okay, sabse but so getting my point, Munna bhai attack. So whatever they say. Okay. So the point is, first we must respect constitutional institutions, fundamental duty first. Respect the institutions and the ideals of the constitutional national anthem, national flag. So we must respect UPSC. Technically the word should have been removed, not impeached. So what are the three reasons why president is impeached while all others are removed? Pehla, in the impeachment is only for the violation of the constitution. President is impeached for violation of the constitution. Judges are removed for proved misbehavior or incapacity. Second important point, dear students, दूसरी बात, the process of impeachment is mentioned in the constitution. In case of judges, only the majority is mentioned. Process is mentioned in Judges Inquiries Act passed by Parliament. दूसरा. तीसरा, there is nobody above the president to remove him. The moment House passes a motion, president stands impeached. In case of judges, House will pass the motion, then president will issue an order of removal. So that is why we use the term removal for judges and we use the term impeachment for president. Now I will ask you one question where there is a common confusion. I know most of the places where you have the confusion. Now you tell me what is the majority to impeach the president and what is the majority to remove the judges. Difference. The biggest misnomer in the world, the big misnomer or confusion in the world is special majority. The moment you say 2/3 और special, पूरा समझिए कि दही में आप दूध में आपने दही डाल दी, क्योंकि special और ये सब कुछ है. Special, somebody will say who is preparing for any one day exam, you cannot dare to say special, क्योंकि special is also divided into various kinds. UPSC is not mama that भगना इस साल appear कर रहा है, easy question देते हैं. This time my niece is appearing, let's set an easy question. इसको ज़्यादा हो सकता है नहीं. They will, all the 4 options would be 4 brothers wearing the same shirt pant. Get it? Judma brothers wearing the, so they don't care if you know special majority. There are various kinds of special majority. I know that there is a confusion here. Now you tell me what is the difference in majority when it comes to removal of judges and president. Then we'll go back to that question. Two-thirds of the, this I have explicitly mentioned in the classroom. 2/3 of the total membership of the house. यहाँ क्या कह रहा है? Absolute majority plus 2/3 of the members present and voting. So if 100 is the total strength, people present are 90 and all of them voted, you require 60, 2/3 of 90. Here 100 is the total strength, who is present or not present कोई मतलब नहीं है. This is a static number, you require 2/3 of total membership, that is, so it is 67. So in case of president it is 2/3 of the total membership. In case of judges it is 2/3 of the members present and voting. And just as a word of caution, please go and see there are different kinds of majority in the constitution. Special majority is the biggest confusion. Special majority के 54 type हैं. So please go and read these 4 articles in the constitution. Article 249, Raj Sabha, empowering. Article 169, Legislative Council on the recommendation of Legislative Assembly. Article 368. You see different kinds of majority over here. तब आपको लगे ओ इसमें भी है. यूपीएससी वहीं से क्वेश्चन पूछेगा जहां उसको मालूम है कि आपको नहीं मालूम. एकदम सही भाई ने बिल्कुल ही. सो द पॉइंट इज कि 249, 169 एंड 368. सो 249 में क्या मेजॉरिटी है, 169 में क्या मेजॉरिटी है और 3. All these articles have different majority. Honestly, it would be a day of, if you make a mistake on special majority, then what? If you make a mistake on majority, then okay, so please don't make a mistake on this. Okay, let's come back to, there is an English saying, for those who mind, for जैसे कहता है यार माइंड मत करना. For those who mind, they don't matter. For those who matter, they never mind. लोग कहते हैं ना यार माइंड मत करना बात का. For those who mind, जो माइंड करते हैं, they don't matter. For those who matter, they never mind. Getting my point? 2 people were arguing. I say this always. This should be. 2 people will arguing. One person said he said so many wrong things. You didn't say anything. He always says. He said, nah, I always say you are right. I said, but that's absolutely wrong. So, yes, you are right. So the point is, you should not argue and just let's come to this question. It says, now please dear student, the motion to impeach a judge of Supreme Court of India cannot be rejected by Speaker of the Lok Sabha as per the Judges Inquiries Act. लिखा हुआ है Judges Inquiries Act में. It is mentioned in Judges Inquiries Act. M. Lakshmikant, Tata Magro Hill 6th edition, Vision IAS printed material में लिखा हुआ है. The judge may or may not admit the chairman or the speaker may or may not admit such motion. I will say, the motion to remove one of the Chief Justices of India was introduced by the opposition in Raj Sabha, which was rejected by the chairman. So ऐसा कोई motion chairman admit भी कर सकते हैं या refuse भी कर सकते. So the chairman may admit the motion or may not admit the motion, and this question was lifted from current affairs, where opposition party introduced a motion to remove the Chief Justice of India, which was rejected by the chairman. Now let's see the statement. कह रहा है, the motion to impeach a judge of Supreme Court cannot be rejected by Speaker of the Lok Sabha. Can be rejected or cannot be rejected? It can be rejected by the Speaker as well as the chairman, and it was rejected by the chairman in Raj Sabha. So ये Speaker का discretion है chairman का motion को accept करे या ना करे. So this is the discretion of Speaker or the chairman whether. So this statement is correct or wrong? This statement is wrong. ये कह रहा है स्पीकर मोशन को रिजेक्ट नहीं कर सकते हैं. स्पीकर कैन नॉट रिजेक्ट द मोशन. कैन द स्पीकर रिजेक्ट द मोशन? यस, स्पीकर मोशन को रिजेक्ट कर सकते हैं. इट सेज द स्पीकर कैन नॉट बी रिजेक्टेड. सो दिस स्टेटमेंट इज अ रॉन्ग. द कॉन्स्टिट्यूशन ऑफ इंडिया डिफाइंस प्रूव्ड मिसबिहेवियर एंड इनकैपेसिटी. ओके, प्रूव्ड मिसबिहेवियर और इनकैपेसिटी हैज नॉट बीन डिफाइंड इन द कॉन्स्टिट्यूशन. इनफैक्ट ये क्वेश्चन कई बार आता है. सेक्युलरिज्म, माइनॉरिटी, अनटचेबिलिटी, प्रूव्ड मिसबिहेवियर, इनकैपेसिटी, वायलेशन ऑफ द कॉन्स्टिट्यूशन or untouchability, all these things are not defined in the constitution. Where all the definitions are there? बताइए, पूरे कॉन्स्टिट्यूशन का सारा डेफिनेशन कहां है? बताइए. 366, आर्टिकल 360, अब एक एग्जाम्पल देते हैं, बिना चटनी गिराए तो he says ना कि चटनी गिराएंगे तो, so says ना कि इनको बड़ा चटनी गिरा के ही दिखाना, he has to show. Now article 279A, it says that one minister from every state will participate in GST council. In Lakshmikant it is written one minister from every state, normally the finance minister, and also union territory with legislative assembly. Yani one minister will participate from every state and also from those union territories with legislative. But in article 279A to likha hua hai only a minister from the state. And you cannot assume something. You cannot, I'll give you a reason. In the constituent assembly, एक committee की meeting चल रही थी. A committee's meeting was going on. Acharya Kripalani ji was there and Dr. B.R. Ambedkar ji was there. So something he said, okay, and then Dr. Ambedkar said something, so he said कि हाँ, that goes without saying. मतलब of course आप सही बोल रहे हैं, इसको तो बोलने की भी जरूरत नहीं है, ये तो है ही. Getting my point? ये तो है ही. So he says कि हाँ, that goes with. Dr. Ambedkar said, no, nothing in the constitution goes without saying. Nothing in the constitution goes without saying. So article 279A says that GST council may every state finance minister or any other minister nominated will represent in GST council. In all the books you will find union territories with legislature will also be represented in. So ye apne se nahi. Now in article 366 definition 26AB it is mentioned that the term state in article 279A will also include union territory with legislature. So article 366 में क्या है, ऊपर से नीचे तक it has all the definition. I don't want to open the Pandora's box. Otherwise I'll be talking about article 341, article 342, who is a scheduled caste, who is a scheduled tribe. There are ample of connotations coming from article 366. But one thing which I want to say, sometime if you get time, you can go through article 366 to go through all the definitions. Now let's come to this. कह रहा है, the motion to impeach a judge of Supreme Court cannot be rejected by speaker. It can be rejected by speaker. So this statement is a wrong statement. The Constitution of India defines and gives details of what constitutes incapacity. Incapacity has not been defined by the Constitution. In fact, violation of the Constitution has also been not defined. Okay. The detail of the process of impeachment of judges is given in Judges Inquiries Act. Correct है या false है? Yes, the details of removal is given in Judges Inquiries Act. आगे देखते हैं. If the motion for impeachment of judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership and by not less than 2/3 members present and voting. So ये correct है और ये correct है and ये दोनों incorrect है. So we will settle for option C, that is 3 and 4. अब फिर से कह रहा हूं, with respect to president, the impeachment is mentioned in the constitution and the process is also mentioned in the constitution. Judges के case में process is not mentioned in the constitution. Process is mentioned in Judges Inquiries Act and the majority is mentioned in the constitution. ये question क्यों पूछा? Why this question was asked? Because same year a motion was introduced to remove the Chief Justice of India, which was rejected by the chairman of Rajya Sabha. So this question was from current affairs. Okay, so this is something which is important. Now, 9th schedule was introduced in the Constitution of India during the prime ministership of which prime minister? Jawaharlal Nehru ji. Now, thoda sa 9th schedule because it is very important. सबसे पहले कहानी, so we'll take 5 minutes over this. Champakam Dorai Ranjan. Okay, so article 15 of the Constitution 15(1) says there will be no discrimination on the grounds of religion, race, caste, sex, place of birth. 15(2) says, article 15(2), access to bathing ghats, etc., restaurants, etc. Okay, good. So the point is 15(3) says nothing in the Constitution that prevent the state from making any special provision for women and children. Bas, itna hi tha. In the original Constitution, you had Article 15 Clause 1, you have Article 15 Clause 2 and Article 15 Clause 3. Article 15 Clause 1 says The state shall not discriminate on the ground of religion, race, caste, sex, place of birth. 15 clause 2 says access to public ghats, restaurants, etc. will not be discriminated. Third, nothing can prevent the state from making any special provision for women and children. Bas. Article 15, 1, 2, 3 और था ही नहीं. Then what happened? Two things. One, many of the state legislative assemblies were making laws. For example, I am minister in 1950. I look left, it says right to property, article 19(1)(f). I look right, article 39(c). Operation of economic system should not result in concentration of wealth. Article 38, minimize inequalities in income and eliminate inequalities in status. So when I look into article 38 and article 39(b) and (c), I have to minimize inequalities in income. But when I look into article 19(1) of there is a fundamental right to property. So ho gaya. The moment I bring Zamindari Abolition Act in the state legislative assembly, Zamindar immediately will go to Supreme Court ki dekhiye mera fund. So I am a minister, I am planning to introduce a Zamindari Abolition Act. I see article 38 which says social, economic and political justice, minimize inequalities in income and eliminate inequalities in status, because it is impossible to eliminate inequalities in income. Those who work hard will get more. Everyone will get same, so why will they work hard? So Constitution says minimize inequalities in income and eliminate inequalities in status. Article 39(c), operation of economic system in India should avoid concentration of wealth. भारत की अर्थव्यवस्था में wealth concentrate नहीं होना चाहिए. So when I want to implement article 38, 39(b) and (c) and bring Zamindari Abolition Act, this person moves Supreme Court, he says article 19(1)(f) is being violated. So there is a dichotomy between fundamental rights and DPSP. That meme goes the round where he says fundamental rights and DPSP after Minerva Mills case. So the point, okay, now coming to this. एक communal order था. Communal doesn't mean communalism, community based order था कि medical colleges में certain caste based reservation was there. Okay. So 1927 communal order of government of Madras. One girl moved Supreme Court. Article 15 says there will be no discrimination on the basis of caste. Okay. So and what is the difference between article 15 and 16? अब तो ये तो सबसे बड़ा confusion है students को कि 15 और 16 में क्या अंतर है. 15 की मूवी भी देख लिए. Yes. So now let me tell you. Article 16 deals with पब्लिक एम्प्लॉयमेंट, जो मैं क्लास में बहुत ज्यादा एम्फेसाइज करता हूं. आर्टिकल 15 डील्स विथ एवरीथिंग फ्रॉम पिन टू एरोप्लेन. आर्टिकल 15 डील्स विथ एवरीथिंग फ्रॉम पिन टू एरोप्लेन. आर्टिकल 16 ओनली डील्स विथ पब्लिक एम्प्लॉयमेंट. सो इफ अ young what you call a young man is or a woman is appointed as assistant professor at IIT Delhi, एक young woman is appointed as assistant professor in IIT Delhi, it will be covered under 16 or 15. It will be, फिर से कह रहा हूं, Article 15 covers everything on earth. पेंसिल से लेके एरोप्लेन तक, ट्रोपोस्फेयर, स्ट्रेटोस्फेयर, मेसोस्फेयर, थर्मोस्फेयर, आइजोस्फेयर, एक्सोस्फेयर, everything is covered by Article 15 other than public employment. Other than public employment. Now I am telling a young woman is appointed at IIT Delhi as assistant professor in civil engineering department. So this will as under reservation. It will be covered under 15 or 16. It will be covered under 16. That same young girl got admission at IIT Delhi. It will be covered under 16 or 15. 15. Because 15 deals with everything other than public employment, and 16 only deals with public employment and reservation in promotion. So everything on earth is covered under 15 other than reservation in public employment. I don't want to go because this requires at least 4 hours. But anyways, now 15 to 16. अब आते हैं वापस. Now first constitutional amendment इस बार भी पूछा है, so we will discuss that. There was an order कि there will be some reservation in medical college. A girl moved Supreme Court. अच्छा, reservation in a educational institution will be covered under 15 or 16. Reservation in educational institution, admission will be covered under 15. Appointment as faculty will be covered under 16. फिर से कह रहा हूं, admission will be covered under 15 and appointment as faculty will be covered under 6. क्यों? आर्टिकल 15 में देयर कैन बी अ डिस्क्रिमिनेशन ऑन द ग्राउंड ऑफ रेसिडेंस, ठीक है, हो सकता है. अंबेडकर यूनिवर्सिटी इज देयर इन दिल्ली, अंबेडकर यूनिवर्सिटी है ना दिल्ली में, द्वारका में कश्मीरी गेट इज 85% सीट्स आर रिजर्व्ड हु हैव डन देयर क्वालिफाइंग एग्जाम फ्रॉम दिल्ली. So in Ambedkar University, a state university, 85% seats are for those who have done their qualifying exam from Delhi. Kyun? Because it is covered under Article 15, which does not ban discrimination on the basis of residence. In medical college, 85% seats are state quota and 15% seats are all India quota in state medical colleges. Kyunki Article 15 deals with education. In public employment, there is additional ground. There can be no discrimination on the ground of residence also. So Article 15, if a young boy takes admission at IIT Delhi, it will be covered under 15 or 16? 15. If the same young boy becomes assistant professor at IIT Delhi, it will be covered under 16. Because in 15, residence can be a ground of discrimination. In 16, residence cannot be a ground of discussion unless the parliament allows the same under Article 16 clause 3. अब आते हैं. So there was a reservation in a medical college. The girl moved Supreme Court and said reservation in medical college is covered under 15 and 15 में there is no discrimination on the basis of caste. Supreme Court said बिल्कुल सही. There will be no reservation in public employment. So to overturn the judgment of Supreme Court, the parliament added Article 15 clause 4 by first constitutional amendment and Article 15 clause 5 reservation directly in educational institution by 93rd. Getting my to overturn the judgment of Supreme Court. So first constitutional amendment लाने का purpose क्या था? 1. चंपकम दोराई रंजन केस. दूसरा, in various state legislative assemblies, especially for example you have a legislative assembly of United States of Bihar. So in United States of Bihar, if a law is passed, I always call, okay. So in United States of Bihar, the state legislative assembly passed the Zamindari Abolition Act to implement Article 38, social, economic and political justice, minimize inequalities in income, and Article 39C, economic system should not promote concentration of wealth. The moment Zamindari abolition system was passed by the state legislative of United States of Bihar, Zamindar moved Supreme Court. देखिए मेरा article 19 1F is being violated. So conflict हो गया किसमें? Fundamental rights versus if you want to implement DPSP, you are violating fundamental. So to overcome that inconsistency, 9th schedule was added by first Constitutional Amendment Act. Surprisingly, first Constitutional Amendment Act was not even passed by Parliament. Parliament met for the first time in May 1952. First Constitutional Amendment Act was passed by same Constituent Assembly which was acting as Parliament till 1952. So first Constitutional Amendment Act was not even passed by Parliament, it was passed by क्योंकि Parliament तो आया ही है 1952 मई में. So first Constitutional Amendment Act was actually passed by Constituent Assembly functioning as Parliament. उसी Constituent Assembly जिसने Constitution बनाया, same Constituent Assembly ने First Constitution Amendment Act pass किया 1951. So the purpose of first Constitutional Amendment Act was to add Article 15 Clause 4 to overcome the judgment of Supreme Court on Champakam, Durai Ranjan case and to add 9th schedule to remove inconsistency between fundamental rights and DPSP. It's a long story. I don't want to go. Now let's come to the question. If you want, we can take a break also. Don't worry. I know you want. I just asked. So the ninth schedule was introduced in the Constitution during the Prime Ministership of Jawaharlal Nehru ji. Okay, we'll just end this. It is about to end. अब ये क्वेश्चन है प्रिवेंशन ऑफ डिस्क्वालिफिकेशन एक्ट. तो भाई सबसे पहले एग्जाम्पल चटनी गिरा के मजा आता है. सो जया बच्चन जी was she still a member of Rajya Sabha. गौर से सुनिए. Under Article 102 and 103 deals with Office of Profit. क्या भाई? If I am a member of legislature, my job is to make laws My job is to take care of my constituency. If I am a Rajya Sabha member representing my state, my job is not to get enticed by the executive कि मुझे थोड़ा मलाई, मैं भी minister. My job, there is a separation of powers, although in a diluted, not in watertight sense. So legislature must perform their job. They cannot take any office other than the office of minister. Yani legislature cannot become part of executive other than the office of minister. Yani legislature agar minister bante hain, then it's fine. It is written in the constitution that minister will not be an office of profit. Otherwise, ye nahi ki thoda ganna udyog ke chairman ban jate. Getting it? So legislature should not be enticed, induced by the lucrative offer of executive. Otherwise, they will not be able to do their duties impartially as a legislature. How will they hold executive accountable when they are given freebies by the, not freebies, by the chocolate by the executive? So the Constitution of India, Article 102 and 103 says that if a member of legislature takes a post of executive other than the post of minister, he will be disqualified for holding an office of profit. एक और चीज लिखा है, पार्लियामेंट किसी पोस्ट को ऑफिस ऑफ प्रॉफिट से एग्जेम्प्ट कर सकती है. पार्लियामेंट कैन एग्जेम्प्ट एनी पोस्ट फ्रॉम ऑफिस ऑफ प्रॉफिट, और पार्लियामेंट ने पास किया प्रिवेंशन ऑफ ऑफिस ऑफ प्रॉफिट प्रिवेंशन ऑफ डिस्क्वालिफिकेशन एक्ट. सो पार्लियामेंट ने पास किया ऑफिस ऑफ प्रॉफिट प्रिवेंशन ऑफ डिस्क्वालिफिकेशन एक्ट. अब हुआ क्या, जया बच्चन जी वॉज अ मेंबर ऑफ पार्लियामेंट फ्रॉम यूपी राज्यसभा, ओके, एंड शी वॉज अपॉइंटेड एज अ चेयरमैन ऑफ फिल्म डेवलपमेंट काउंसिल इन यूपी. And she was also a member of Parliament of Rajya Sabha. Somebody filed a petition in Supreme Court. She is holding an office of profit. Supreme Court went through and asked UP government, okay, what all facilities she is getting as a chairman of film development. They responded that she is given certain salary, certain not salary, certain chauffeur-driven car. Okay, so Supreme Court said no. This is an office of profit and disqualified her. Then she got disqualified. Then the parliament passed a law. Office of Profit Prevention of Disqualification Act was already there. It not passed the law, it amended the law and added there that film development would be an exempted thing, and also added chairman of National Advisory Council will also be exempted. And so what happened, one more person was a member of parliament in Lok Sabha and she was also chairman of National Advisory Council. Although no petition was filed, but there was an apprehension that since Jaya Bachchan ji has been disqualified in Jaya Bachchan versus Union of India, so she will also be disqualified. So Jaya Bachchan ji was disqualified and she also resigned from parliament as a member of Lok Sabha. The moment both of them, one got disqualified, second resigned, parliament passed the law. Office of Profit Prevention of Disqualification Act was already there, amended and added chairman National Advisory Council and chairman film development will not be an office of profit. By-election was held. Jaya ji was also again elected and that member of parliament was also again elected from Raebareli. Okay, so the point is ki, so this is something, this is a factual, this mein koi, we are least concerned. Politics and all we leave outside the classroom. No ideology, I'm least concerned. We are here for, this is not a no politics at all, 0%. Our purpose is what is the demand of the, this is a case. Chairman at National Advisory Council actually was added, and Jaya Bachchan versus Union of India is most important case on office of profit. तो ये तो fact है, इसमें कोई politics की सवाल ही नहीं है. We leave all those identities outside the classroom. Now the point is, so office of profit का purpose है कि legislature must do their duty. They should not get enticed by the executive. Now let's see this. The Parliament Prevention of Disqualification Act exempts certain posts from disqualification on grounds of office of profit. Correct है कि false है? क्या पार्लियामेंट किसी पोस्ट को ऑफिस ऑफ प्रॉफिट से एग्जेम्प्ट कर सकती है या नहीं कर सकती है? सो ये स्टेटमेंट सही है या गलत है? ये स्टेटमेंट बिल्कुल सही है. नेक्स्ट, द अबव मेंशन एक्ट वाज अमेंडेड 5 times. This was Plutonian question. Nobody on earth knows that it has been amended 5 times, although it is a correct statement, but I don't expect anybody to know that how many times act has been amended. Leave that. Let's arrive. Everyone on earth knows that office of profit has not been defined in the first line that we say on office of profit, among the first line, that office of profit has not been defined in constitution or any law. Case by case, Supreme Court and Election Commission of India decides that whether it is an office of profit or not, depending upon the benefits that is being offered. So office of profit has not been defined. It depends upon case by case. एक और case ले लेते हैं. 23 MLAs of Aam Aadmi Party were appointed as parliamentary secretary. Somebody made a complaint in Election Commission of India. This is office of profit. Election Commission of India recommended to the president to disqualify, because in Delhi chief minister is appointed by the president, so disqualification will come from president, otherwise it is governor. So Election Commission of India gave a binding recommendation to president to disqualify 23 members of Aam Aadmi Party as being holding the post of office of profit, and Honorable President Ramnath Kovind ji, acting on the advice of Election Commission of India, disqualified all 23 MLAs. All 23 MLAs went to Delhi High Court. Delhi High Court said that we are not concerned for the time being whether they were holding office of profit or not. Election Commission of India deciding over office of profit acts as a quasi-judicial body. Why these MLAs were not given their opinion, a chance to prove their point? It is a violation of principles of natural justice. क्यों इनको मौका नहीं दिया जवाब देने के लिए कि इनको ये होल्ड? So there was no chance given to 23 MLAs to represent their views. This is a violation of principle of natural justice. And in Subramaniam Swamy case, Supreme Court has already ruled in the past that whenever Election Commission is deciding over office of profit, it will act as a quasi-judicial body. So violation. So all 23 MLAs were restored because there was a violation of principle of natural justice, which is going to come LATER in this judgment. Okay, in the discussion. Okay, so the term office of profit is well defined in the constitution. True or false? False. So 3 we will eliminate. What is the answer? We will eliminate 3. What is the answer? So even if you don't know that the act has been, amended 5 times, you know that office of profit has not been defined. Eliminate 3. What is the answer? UPSC knows that you don't know that the act has been amended 5 times, but UPSC expects you to know that office of profit has not been defined in the constitution. You will arrive at an answer by eliminating 3. The only option jo Naraz Fufa ji bach gaya, that is 1 and 2, that is 89A. That is 1 and 2. We'll take a break after we wrap up. हाँ, elimination नहीं होता तो गलत भी होता है आंसर. फिर दो बातें होती. पहला गलत होता. Okay. Second, you could not have attempted, because then it would become a brutally tough question. How many times a particular law has been amended when there is so many laws that you are dealing is something which is not expected from an aspirant. So I don't think UPSC will ask a question without giving you a reasonable point to eliminate, unless it is question paper of 2023. Okay. So now let's see this, under which we were dealing with only 2019 for 2 hours. Okay, we'll wrap up fast. I knew that, I told you that this is a 17-hour minimum on a conservative note. Under which schedule of the constitution can the transfer of land to private parties? Samatha versus State of Andhra Pradesh. A very, very landmark judgment on tribal rights under the 5th schedule of the constitution. So, SAMATHA versus State of Andhra Pradesh. Under which schedule of the constitution can tribal land? इससे easy question अभी तक कोई आया ही नहीं है. Why? 12th schedule, you know that there are 18 subjects related to municipalities. 9th schedule, you know, has nothing to do with this. 3rd schedule, you know, has oath and affirmation. बचा क्या? 5th schedule. So the 6th कहाँ है ही नहीं इसमें. So it is 5th schedule. So 3rd schedule is oath and affirmation. 1st schedule is states and UTs. 2nd schedule is salaries and allowances. 3rd schedule is oath and affirmation. Those who are atheist, they will not say I do swear in the name of God. They'll say I do solemnly affirm. So for atheist it is affirmation. For theist it is oath. 4th schedule is which state has how many seats in Rajya Sabha. I am not concerned. Which state has how many seats in Lok Sabha, where it is given. I have told in the class. So ye fourth schedule, UPSC will not ask for which state has how many seats in Rajya Sabha, which of the following. They know this is a LDC question, SSC question. They will ask which states have how many seats in Lok Sabha. That is given in first schedule of Representation of People Act 1950. Okay, so we will easily settle for B. We can take a quick break of 5 minutes. We come back and then we will discuss. Okay, you can ask at the end also. I'll take as many questions as you want. Okay. Not more than 5 because you will be enriched by the lecture, don't worry, but you need to give some time. Okay, so we will be having discussion. So what is the basis of parliamentary system of government? Yaad rakhiye. The basis of parliamentary system of government is Article 75 Clause 3. That the Council of Ministers shall be collectively responsible to House of People. Okay. So what is a parliamentary system? All political parties are represented in the government. This is Indian National Congress represented in government. A parliamentary system of government is all parties are represented in government. Is Indian National Congress represented in government? No. So this statement is wrong. The government is responsible to the parliament and can be removed. Yes. The government is elected by the people. Has there been any election of government in India? Has election, if there is a question that what is the tenure of the office of Prime Minister? अगर कोई क्वेश्चन आता है, the Prime Minister of India has a tenure of, दुनिया की कोई ताकत एक दिन का टेन्योर नहीं दे सकती है. There is no tenure of the office of Prime Minister. It is wrong to say that 5 years. 5 years is the tenure of Lok. The normal tenure of Lok Sabha is 5 years from its first sitting. It can be dissolved earlier. The Prime Minister has no tenure, remains in office at the pleasure of President as long as commands majority in Lok Sabha. If there is a question, the Prime Minister has a tenure of 5 years, 3 years, 2 years, none of the above, you will go for none of the above. Because Prime Minister, if Prime Minister had a tenure, why Morarji Desai ji was removed? Why Chaudhary Charan Singh ji was there for so small? Why VP Singh ji lost majority? Why Chandrasekhar ji lost majority? Why initially Vajpayee ji was for 13 days and later he came again, became Prime Minister and completed tenure? Why so many Congress governments, other governments also have lost? So the Prime Minister do not have a tenure, remains in office. Article 75 Clause 2. The Council of Ministers hold office at the pleasure of President. So there is no tenure. अगर ऐसा क्वेश्चन आता है कि what is the tenure of the office of Prime Minister, बिल्कुल tenure नहीं है. There is no tenure. Answer would be none of the above. क्योंकि there is no fixed tenure. The ministers enjoy office at the pleasure of President. हाँ, the pleasure will not be invoked as long as they have majority in the pleasure majority in Lok Sabha. Okay, so C is the correct answer. The government is government. B for Bombay is the correct answer. Government is responsible to the parliament and can be removed by it. So in question number 21 we have B. Which part of the constitution declares the ideal of welfare state? सीधा Article 38. Article 38 क्या क्या कहता है? 1. Welfare state. 2. Social, political and economic justice. Dr. Ambedkar said, political democracy is a top dressing on Indian soil, which is essentially undemocratic. Dr. B.R. Ambedkar. Political democracy is a top dressing on Indian soil, which is essentially one of the very famous statements. For example, there is X and Y. X come from a weaker section and Y is a rich landlord. So on 26 January 1950, X and Y both got the right to vote. What is the value of X's vote? X एक गरीब आदमी है और disadvantageous section से है. X के vote की क्या value है? What is the value of vote of X is 1 and the Y's vote is also 1. So there is political democracy. X and Y have same. But X goes to the polling booth in a cycle and Y in a Lamborghini. So there is a political democracy, but there is no economic. X is subjected to caste slur. So there is a political democracy, but not economic and social. He said we are giving right to vote to everyone. That is why he said political democracy is a top dressing on Indian soil, which is essentially undemocratic. And just to complement that, further says that political democracy cannot exist alone. It should be coupled with social and economic democracy. So Article 38 कहता है welfare state, political, social and economic justice, and most importantly, the last point, which says minimize inequalities in income. Income में inequality को minimize कीजिए and eliminate inequalities in status. Do you think it is possible to eliminate inequalities in income? इस क्लास में जितने लोग समाज में सबके पास एक ही पैसा हो. It is impossible. Then why will people work hard if they get the same money by not working hard? So the founding mothers in the Constituent Assembly, fathers in the Constituent Assembly said that minimize inequalities in income and eliminate inequalities in status. Inequality in income को minimize कीजिए और inequality in status को eliminate. गरीब और अमीर को थाने में same treatment होगा. The rich and poor are same in the eyes of law. But when it comes to inequality in income, you have to minimize. So the idea of welfare, jaldi boli, we have less time. Haan. Okay. See, first of all, this is not, one student is asking that whether economic democracy can be achieved. Economic democracy is a silent revolution. You cannot achieve economic democracy at one go. You can give political right to vote by inserting Article 326 of the Constitution. Zamindari abolition. Article 39B, that resources should be used for common good. Article 39C, operation of economic system should not result in concentration of wealth. Progressive taxation under direct tax. So economic democracy gradually. What is the kind of socialism that we practice? We practice Fabian socialism. We practice evolutionary socialism. We don't practice revolutionary socialism. We want to achieve the same thing, but we will achieve through evolutionary means rather than revolution. So political democracy was possible. Economic democracy will take time. Okay, we'll take all your questions. So briefly, because I thought we are into 21. So which part of the Constitution declares the ideal of welfare state? Which part? DPSP Article 38 of the Constitution. So we will easily settle for directive principles of. The 9th schedule was introduced. Okay. One common agreement between Gandhism and Marxism, directly lifted from. First, most important thing, 2-3 text. Don't read the text, go through the synopsis. One is Hind Swaraj, other is Village Swaraj. So this statement literally I read in my college. When I was deeply attracted towards Gandhian philosophy, I was constantly reading Gandhiji. So there, this is although this is also mentioned in that. Okay, so what is common between Gandhiji and Marx? Final goal of stateless society. Although difference hai, Gandhiji believed in spiritual way. What Marx believed in revolutionary methods, Gandhiji believed in evolutionary methods. Next important thing, Marx was of the view that means and end not matters a lot. It can be revolutionary. Gandhiji said no, means should also be pure and end should also be pure. So we will settle for final goal of a stateless society 24A. In context of India, which of the following is the characteristic appropriate for bureaucracy? What is bureaucracy? Although the very term bureaucracy is a sort of, because it is democracy. Bureaucracy, cracy means rule. Democracy means rule of the people. Bureau term has come from those people who used to sit at the desk, bureaucrat. So bureaucracy se better term has civil. UPSC in its syllabus uses the term civil services rather using the term. In GS paper 2, they say role of civil services in a democracy. They don't say role of bureaucracy, because cracy means rule. It is not the rule of bureaucrat. It is the rule of people, for the people and by the people. Abraham Lincoln. Now the point is, so it says, what is the characteristic of bureaucracy? Bureaucracy acts as a bridge between citizen and the government. In India, we have permanent executive. US में नहीं है. Many countries don't have permanent executive. Even if the government changes, there is a civil services to provide continuity in governance. In US, what happens? I get elected as president. I will bring 400 people with me. So all the top civil servants would be directly appointed by the president, and when president demits office, all of them would be removed and the new president will come. So there is no permanent civil services at the top level. In India, we have permanent bureaucracy, so that there should be continuity, and most importantly, civil servants should be neutral, and it should be on merit-based system rather than rather than appointment by the president. So we will be an agency for parliamentary democracy. Even in presidential democracy, you can have bureaucracy. So there is no question of linking it with parliamentary. An agency for strengthening federalism. Indirectly it can, but not directly. Agency for facilitating political stability. So many states government changed. Do you think bureaucracy was able to stop that change in government? So political stability they may provide, but this is not a reason. Last is an agency for implementation of public policy. Even by a naive reading of the statements, you can conclude that the opt statement out of the 4, this is the best one. So we can also settle for 25. Now, this is again, we'll take your question. Please note down, because otherwise we'll be continuing till 10 PM. Okay. So the point, unnecessary nahi, wo mujhe malum. Suniye, the point of C, you may have an opinion. You may have an opinion. Wo to sample of a question. A sample question. I'll share a sample question, and then we will. There can be sample question. It discuss the relevance of fundamental rights through the prism of monsoon, keeping nuclear fission in mind. Kya question hai? Dekha. Not even a question. Okay. Now the point is, so preamble to the Constitution of India is, now this is a very important thing. Preamble is non-justiciable. कहने का मतलब ये है, I'll speak in English also, कि preamble reflects the minds of the makers of the Constitution. Preamble के होने से ऐसा नहीं है कि preamble को enforce कराने के लिए आप कोर्ट जा सकते हैं. You cannot go to court to get the preamble enforced, but preamble, why is India secular? Why is India secular? Because it is written in the preamble, or because it is written in Article 25? Subject to public order, morality and health, all persons shall be equally entitled to freedom of conscience, profess, practice, propagate and conscience. So India is secular because not it is mentioned in preamble, because it is mentioned in Article 25. Idea of justice, because of idea of equality is provided in fundamental rights. Preamble is more of a philosophical document to get an insight into the minds of the makers of Constitution. So preamble has no value independently of the provisions of the Constitution. The mere violation of preamble cannot be challenged in the court unless it is a direct contravention of a provision in the. India is not secular because the term secular was added by 42nd Amendment, came into force on 3rd January 1977. Even without the presence of the term secular, preambles, the Constitution of India in Article 25, individual rights, 26, collective right, 27, positive character of secularism, 28, educational institutions deprived of religious instruction, other than some exceptions. So India is secular because of Article 25, 26, 27 and 28. Not because India is secular because it is mentioned in the preamble. Preamble, why preamble was adopted at the end? Consciously, advertently, knowingly, deliberately, with uttermost sincerity, preamble was adopted on 26 November 1949 to give a message to the world that whatever is written in the Constitution has already been incorporated in the Constitution. जानबूझ के preamble को last में adopt किया गया ताकि दुनिया को ये पता चले कि preamble में जो बातें लिखी गई हैं वो Constitution में already incorporate, और ये question आया है. Deliberately, preamble was adopted on 26 November 1949, so to give a message that the aspirations of the preamble have been incorporated in the Constitution. Getting my point? So, dear students, we have ab padhte hain. Now, does preamble has an independent value? Initially, Supreme Court in Re Berubadi Union case said that preamble is not part of the Constitution. On 24th April 1973, it said no, preamble is part of the Constitution. But preamble is, the Constitution of India doesn't promote socialism because socialist term is mentioned in preamble. Because Article 38 says that social, economic, political justice, welfare state. 39, you have so many A to F. 39A, free legal aid. You have 41, right to work. 42, maternity relief. 43, living age. 43A, participation of workers in the management of industry. 47, public health. Getting my point? So that is why India is socialist, not because it is mentioned in the preamble. So preamble has no value independently of other provisions of the Constitution. You cannot go to the court to say that preamble is being violated. You will go to the court and say that fundamental rights are being violated. Let's see. Preamble is a part of Constitution, has no legal effect. Okay, this is also what you call, let's see better, not a part of Constitution, eliminated, because Supreme Court has ruled that preamble is part of the Constitution, has same legal effect as any other part. Has preamble the same legal effect as fundamental rights? No. Is part of the Constitution but has no legal effect independently of other parts. So between A and D, what would be a better answer? D for Delhi would be a better answer. So 26 we will settle for D. Okay. With reference to the provisions contained in part 4, which of the following statements are correct? Part 4 is, what is part 4? Directive principles. So which of the following statements are correct? They shall be enforceable by court. No, they cannot be enforceable by court. They shall not be enforceable by any court. Correct. Article 37 of the Constitution. These principles are non-justiciable, yet they are fundamental for governance. So they are not enforceable by the court. The principles laid are part to influence making laws. This is directly lifted by the Article 37. So statement 2 and statement 3 are correct. Statement 1 is wrong. So we will settle for D for Delhi. Okay. So directive principles of state policy. Okay. Okay. One more thing. The concept of directive principle has been taken from Irish. Content. In Irish Constitution, do you have what you call village panchayat? ST weaker sections, Article 46. Early childhood care and education, Article 45. Agriculture on scientific lines, Article 48. Monuments, Article 49. Promotion of international peace and security, Article 51. The concept may be Irish, but the content is Indian. Preamble, the concept of preamble may have come from United States, but the content of preamble is from the objectives resolution passed by the Constituent Assembly on 22nd January 1947, based on a speech given by Mr. Nehru on 13 December 1946. So you should understand the difference between concept and content. The concept of fundamental rights may be American, but the content of fundamental right is as per Indian understanding. Provisions of reservation and many other things have been incorporated, and Nehru report also is an important source. So now let's see. This is 2 and 3. We will settle for D in question number 28. Now, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he is not a member of legislature of that state. Okay. A person, Dr. Subramaniam Jaishankar, 30th May 2019, 5 p.m. was appointed as a minister, although he was not a member of legislature. कोई भी मंत्री बन सकता है, वो अगर member नहीं है, लेकिन 6 महीने के अंदर उसको जीतना पड़ेगा. पर question क्या कह रहा है? Eligible to vote? 61st Constitutional Amendment Act, what is the minimum age to vote? Article 326, minimum age to vote is 21 or 18? Is 18. But minimum age to contest Lok Sabha election is 25. Raj Sabha election is 30. President is 35. Governor, Vice President 35. Lokpal 45. For Lokpal it is 45. So can a person who is 18 years of age and eligible to vote can be appointed as minister if he is not 25 to be qualified to be a member of Lok Sabha even? So that is something which is a wrong statement. क्यों? क्योंकि कह रहा है who is eligible to vote. Eligible to vote तो 18 में हो सकते हैं. But to contest Lok Sabha election you need to be 25, the minimum. Okay. So this statement is a wrong statement or correct statement? This statement is a wrong statement क्योंकि यहाँ कह रहा है who is eligible to vote. Otherwise this statement is correct. According to RPA 1951, such a beautiful law, इससे इतना question इस बार आएगा. This year also they will ask a question from RPA 1951. A person convicted of criminal offense sentenced to not 5 years, sentenced to 2 years. But I will very humbly request you, go and read section 8 of RPA 1951 very cleverly, very clearly, because it is not that simple. We have discussed in RPA 1951, you remember. It is not that simple, 2 years generally, but there are other laws where you are convicted, even for 1 day you will be disqualified. There are list of laws, listen to me very carefully. Generally, there is a perception that you have to be convicted for 2 years, then only you will be disqualified. But there are certain laws in which that 2-year bar is not there. In these laws, if you are convicted, then you will be disqualified even if you are convicted for 1 day, 6 years from the date of your release. So in section 8, there are 2 categories of things. One, those laws where 2-year bar is not there. In these laws you are convicted, you will be disqualified for 6 years from the date of release. Then generally in other provisions, if you are disqualified, then you convicted, then you will be disqualified for 6 years from the date of your release if you are minimum disqualified for 2 years. So please go and read section 8, which is in news because some members of parliament have been disqualified because they have been convicted under section 499 and 500 of the Indian Penal Code dealing with defamation. Okay. So according to, so this statement is wrong. This statement is wrong. So we will settle for D, neither 1 and 2. Kyun both the statements are wrong? Here they have given 5 years or here they have added eligible to vote. So we'll easily settle for option D for Delhi 29. Okay. If you want to have a holistic, in 5 years, in this 5-year discussion, we'll touch upon almost all areas of UPSC. Of course, due to paucity of time, I cannot take every question, we cannot discuss. You know that is something which is understandable. At least I'll make a mention. Those who are diligent, they can note down and later on you can study on that count. It will help you if you want to, like. Okay. So the President of India can summon a session of Parliament at such place as he or she thinks fit. This is purely Constitution correct. Constitution of India provides for 3 sessions. Nowhere in the Constitution there is mention of any session. Only the maximum gap between 2 sessions shall not exceed 6 months. There is no minimum number of days that the Parliament is required to meet in a year. There is no, this is a correct statement. Because nowhere the Constitution says that Parliament has to meet minimum number of days. So first and third is correct. We will settle for C. Ab gaur se suniye. The President summoning the Parliament, Article 85, and other provisions related to summon, adjourn, sine die, recess and session. These 2 I expect you to have absolute clarity. Some provisions they can ask that in some states recently there have been a dispute where the Council of Ministers has recommended the governor to prepone the session or call for a session which have been asked to reconsider. So there can be a question next year in prelims. Generally, it is understood when the Prime Minister or the Chief Minister is making a recommendation, it becomes binding on the President and the Governor. So here, this is correct क्योंकि Constitution में ऐसा कहीं नहीं दिया गया है कि minimum number of days क्या होगा और Constitution में ये President को power दी गई है. So first or third correct है. So we will settle for C for Calcutta. This is quite an easy question. Okay. Now this question is very important. Because this question actually has been taken from K.S. Puttaswamy versus Union of India. K.S. Puttaswamy ji was a retired judge of Karnataka High Court. He challenged the Aadhaar project. Okay, this itself is a big topic of discussion, right to privacy. Right to privacy in India is a part of right to life, but not an absolute right. We are not US. Texas versus Johnson, I said that day also. In Texas versus Johnson, Johnson burned the flag of USA. And the matter went to US Federal Supreme Court. Supreme Court ruled yes. Johnson's fundamental right says that he can. Burning the flag is one of the forms of expression of Johnson. Texas versus Johnson, Federal Supreme Court of USA. India mein the fundamental rights have been restricted with reasonable restriction because our challenges are different. We are a great country. We have become strong every single day. We have 140 crore, they have 34. They are multiple times bigger than us. We are smaller still, we have 140 crore. So our challenges are different. That is why the founding mothers and fathers in the Constituent Assembly have placed reasonable restrictions while enjoying fundamental. We cannot compare. So the level of absoluteness in America is much more than India. Getting my point? We are not Texas versus Johnson. Now coming back to this very important point, right to privacy is a part of Article 21, but not an absolute right. It can be restricted on 3 grounds. Jaldi bataiye. 1, backed by a law. Whenever someone's right to privacy is being violated, there should be a legislative backing. Second, it should be for a justice or a just base or for a strong cause. That is something which is there. It should be a legitimate, the term Supreme Court uses is legitimate cause. And the most important thing, proportional. Proportional means, for example, a cycle got stolen in the society. You cannot check the mobile phone of everyone for the theft of a cycle, because the cause for which you are violating privacy is not proportional. So the apex court has said that whenever the privacy is invaded, three things should be kept in mind. It should be backed by a law, Indian Telegraph Act, for example. Second, it should be for a legitimate purpose. And most importantly, there should be a proportional cause. There should be a proportional cause. So these are the three preconditions, then only right to privacy can be infringed upon, and undoubtedly right to privacy is a part of right to life. K.S. Puttuswamy versus Union of India. Okay, privacy can be a question. Let's see. Aadhaar metadata cannot be stored more than 3 months. Okay, it is 6 months actually. What is metadata? Data linked to a data. For example, I went to bank, or I wanted to take a mobile connection. So I will authenticate my Aadhaar number. So my authentication is also linked to another data. My data. So one data which gives information about. So principal data is with Unique Identification Authority, but some data I am sharing with Reliance or any other company. So metadata, some data which is linked with a big data. Maximum they can store this authentication for 6 months. So this statement is a wrong one. State cannot enter into any contract with private companies for sharing Aadhaar. Section 57 of the Aadhaar Act stricken down by Supreme Court. I went to take a SIM. So the guy told me that you have to give your Aadhaar, but I know K.S. Puttuswamy versus Union of India, section 57 of the Aadhaar Act was stricken. Now I said, no, I will not give. He said, okay, you go to the next place. I went to the next place and got my SIM on driving license. Because I know that he cannot force me to share my Aadhaar. Section 57 has been stricken down by Supreme Court. So that was done by driving license. Even if you are sharing, you can go for virtual ID. That's, you can change your virtual ID. Go to Aadhaar, download the app, generate virtual ID, print all the time, keep your virtual ID with you. देते रहिए. जैसे ही आपको लगेगा, wherever you feel कि अच्छा virtual ID 10 जगह चली गई है. Now it has been into 10. Immediately click, it will change. The moment you click, it will change. Now you will have a new virtual ID. So always lock your Aadhaar biometric and always generate virtual ID. Now also I have my Aadhaar with virtual ID. If I give, even if it falls down, so I will immediately change my virtual ID. Go to the ID, that is redundant. So this was a judgment ki state cannot enter into private. This is section 57. This is correct. This is wrong. Aadhaar is mandatory for insurance product. Nahi. Aadhaar is not mandatory. Aadhaar is mandatory when you are getting subsidy, which is the fourth statement. Okay. So, kyunki Aadhaar bill was certified as money bill, article 109 and 1110. Both the articles are important. Not only 110, 109 is also equally important for money bill. Go and read 109. So 109 and 110 deals with money bill. So this statement is correct. Aadhaar is mandatory for getting benefits funded from CFI. This is correct. This was judgment of Supreme Court. Insurance ke liye Aadhaar is not mandatory and it is 6 months. So first and third are wrong. Second and fourth are correct. We will settle for B for Bombay. Raj Sabha has equal powers with Lok Sabha for amendment of the Constitution. Very easy, the easiest. For all India services, it can be initiated by Raj Sabha Article 312. Okay. Amending the Constitution, both Raj Sabha and Lok Sabha have equal powers. Removal of the government, no. Article 75 clause 3, it is Lok Sabha, not Raj Sabha. Cut motions, economic cut motion, policy cut motion and token cut motion. During the voting on demand takes place only in Lok Sabha, not in Raj Sabha. So in these two, Lok Sabha is more powerful. In this, Raj Sabha is more powerful. In this, they both are equal. So Raj Sabha has equal powers with Lok Sabha in amendment of the Constitution. So we will settle for 32 ka B. Okay. Now this is again an easy question, although they have framed in such way to frighten. Okay. with reference to the members of parliament local area development scheme, which of the following statement are correct? ये है, Ministry of Statistics and Implementation is the nodal ministry. हर member of parliament को साल में 5 करोड़ रुपए का fund, so that they can recommend 5 crores. So they create durable assets. This is absolutely correct. A specific portion has to be released for SC/ST. This is also correct. ये भी लिखा हुआ है. If you go to the rules, it is कि भाई if there is no scheduled tribe population in the nearest district, if now vice versa also in the state also there is no scheduled tribe population, it can be used for scheduled caste. So there is the thing. So a specific portion has to be for SC/ST. Are sanctioned on yearly basis and unused fund cannot be carried. यही तो खूबी है इस fund की. This is the benefit of this fund. Ki even if it does not get utilized in a year, it can be forwarded to next year. There are very few funds which if don't get utilized in a year, they cannot be forwarded. They can be forwarded to next year. Can you give me another example of a fund which can be forwarded to next year and it is in news? बताइए, बताइए. 15th Finance Commission recommended a modernization of defense fund, which was in news. Modernization of defense fund. It is one fund which can be extended to next year if it is a non-lapsable fund. और इसके बारे में बहुत इशू हुआ 15th Finance Commission. I don't want to go again. It will open a new thing. So MPLAD एक ऐसा फंड है जो एक साल इस्तेमाल नहीं हुआ तो नेक्स्ट ईयर चला जाएगा. MPLAD is one fund which is not used in next year, can be used in next year. So it says it cannot be used. So this is a wrong statement. First statement is correct, कहता है durable asset बनेगा, correct है. Second statement is correct, it is specified for a section is also for SC/ST, correct है. Third statement कहता है it cannot be carried, it can be carried. So third statement एक wrong statement है. And district authority must inspect, this is also correct statement. So this is a factual one. 1, 2 and 4. Let's see. So we will settle for D for Delhi in question number 33 है ना, ठीक है. 33 will settle for D for Delhi. Okay, अब इसमें क्या पढ़ना है? They can say undoubtedly means में question आ सकता है. Discuss critically evaluate the members of parliament local area development fund. So which is the nodal ministry during COVID? Why it was stopped? What is the benefit? Has it contributed anything? This is a pure means breeding ground. So you should be ready on MPLAD. Okay, this is the easiest question. By which of the following fund categories of fundamental right? Protection against untouchability. What is 14 to 18? Right to equality. 19 to 22? Freedom. 23-24 against exploitation. So we have, what is it? Untouchability, Article 17. Untouchability is abolished and practice in any form is forbidden. So which is right to equality? We will settle for 34 ka D. Okay, this question has been asked. In India, separation of power, separation of judiciary from executive is Article 50, which is DPSP. So we will settle for 35B. Now what steps have been taken? This can be a mains question. This can be a mains question. Discuss separation of powers from judiciary, separation of judiciary from executive as implemented. What steps has been taken? CRPC was comprehensively amended in 1973. Most of the magisterial powers, पहले जो civil servant होते थे, state PCS and IAS officers, they all, this is again a new mains topic. Most of the civil servants were have judicial powers also. अब CRPC को amend कर दिया गया है. State PCS officers were appointed as railway magistrates. So state PCS officers and state subordinate judicial service. The state PCS officers also enjoyed judicial powers. Now civil servants say 90% of the judicial powers have been, I'm not saying all, I'm just saying most of the judicial powers have been taken away from civil servant so as to separate judiciary from executive. ऐसा नहीं है कि judicial powers नहीं है. Section 144 of the CRPC, Section 141 of the IPC, Section 188, Section 107. So जैसे in a police commissionerate, the police has magisterial powers. Getting my point? So in order to implement Article 50, separation of judiciary from executive, state PSC and IAS officers, most of the judicial powers have been taken away except the except some powers which is necessary to maintain public order, so as to promote separation of judiciary from executive, which is a part of separation of powers by Montesquieu, Spirit of Laws 1748. So in India, separation of judiciary from executive is Article 40 क्या कहता है? The state shall take steps to separate judiciary from executive in the public services of the state. In the public services of the state. क्या? The exact language of Article 50 is separation of judiciary from executive in the public services of the state. So this is, we will settle for B. Now, along with the budget, Finance Minister places the document of macroeconomic framework statement. You know that this is not Article 112, which is annual financial statement. Macroeconomic stability nahi hai. Or Article 110, of course, it is not there. 113, you know that there are various aspects of appropriation and all. Long-standing parliamentary convention nahi hai. It is Fiscal Responsibility and Budget Management Act of 2003. So this you must have studied in economics. So we will have 36 का D. Interdisciplinary approach. जैसे Finance Commission कभी पेपर 2 में पूछता है, कभी पेपर 3 में पूछता है. What are the recommendations of 14 Finance Commission? Sometimes they will ask in paper 3, sometimes they will ask in paper 2. So there are many topics which have an interdisciplinary approach. Okay. So we will settle for D. This is the question which has been asked 3 times in last 5-6 years. एक ही क्वेश्चन को 3 बार पूछ चुका है, इस बार भी पूछा है. What is a constitutional government? A constitutional government is one which is a limited government. 2 terms that are in news: constitutionalism and constitutional morality. Constitutional morality was used by Dr. B.R. Ambedkar on 4th November 1948 in a speech given in Constituent Assembly, where he attributed the term to George Grote. और उन्होंने कहा constitutional morality is paramount reverence to the constitution, not only in letter but also in spirit. Second, principled unfolding of the work of governance. सरकार अपने काम में spirit of constitution को respect करेगी. And third, most important thing, whenever there is a dispute, it will be solved through constitutional means. So constitutionalism or constitutional morality is so important that now they may not ask, they have been asking so many times. 2021 mains question, first question of GS paper 2. What do you mean by constitutional morality? Discuss the difference. Discuss with respect to the judgment given by Supreme Court. क्यों? Navtej Johar case, Joseph Shine case, decriminalizing consensual sex between adults of the same gender. Supreme Court says Article 21 also includes right to sexual autonomy, bodily autonomy. So society thinks that no, consensual sex between adults of the same gender is socially not correct. Many people may think. Supreme Court says no, there is a clash between constitutional morality and social morality. The constitutional morality will prevail. IPC 497, adultery without the consent of husband. Supreme Court says no, women is not a chattel or the property of the husband. Striken down section 497. Kerala Temple Authorization of Entry into Hindu Places of Worship Act. Section Rule 3B of the Kerala Temple Authorization of Entry into Hindu Places of Worship rules. The women in the age group 10 to 50 are not allowed to enter. Supreme Court says there is a clash between constitutional and religious or social morality. Constitutional morality will prevail. So constitutional morality and constitutionalism is a limited government. An unlimited government is a threat to democracy. And nearly all men can stand adversity. If you want to test a man's character, give him power. So a government should be a limited government. That is constitutionalism. Fundamental rights, most of the fundamental rights are negative in nature. कहाँ बोल रहा है कुछ करो? I am saying most. Most of the fundamental rights says don't do this rather than saying do. Article 14, no person shall be denied equality before law, equal protection of laws. Article 15, the state shall not discriminate on the ground of religion, race, caste, sex, place of birth. Article 16, there shall be equality in matters of public employment. Article 17, untouchability is abolished and practice in any form is forbidden. Article 18, the state shall not award any title except military or academic. हमेशा कह रहा है कुछ नहीं करने. Article 19(1)(a), freedom of speech and expression. B, right to assemble peaceably without arms. C, right to form an association, union or cooperative. D, right to travel throughout the territory of India. E, right to reside and settle. F, right to property. And G, right to practice any trade, occupation, profession or business. So most of the time the state is prohibited from doing something rather than being. कुछ fundamental right है जो positive है, जैसे Article 21A. The state shall provide free and compulsory education to all children in the age group 6 to 14. So most of the fundamental right is actually asking state not to do something rather than asking to do something. Or most of the DPSP says nahi karo. The state shall provide early childhood care and education. 45. The state shall enforce uniform civil code throughout the territory of India for its citizens. 44. The state shall provide living wage. The state shall take the management of workers will participate in the management of industry. The state shall provide maternity relief. The state, among its primary duties, shall take care of public health. Article 47. Develop agriculture on scientific lines. Article 48. Environment. 48A. 49. Protect the archaeological monuments of national importance from spoliation, disfigurement. यानी DPSP में बार बार कह रहा है कि ऐसा कीजिए और फंडामेंटल राइट्स में बार बार कह रहा है ऐसा मत कीजिए. So the most of the fundamental rights may not be positive in nature. Most of the DPSP are positive in nature. So the purpose of fundamental right is to limit the government. So क्या है? Fundamental rights promote constitutionalism. Without fundamental rights, although I'll just add one more line. When US Constitution, what is the history of fundamental rights in the world? When US Constitution was open for ratification by the states, there were two set of scholars, the Federalist and non-Federalist. Some scholars said, "Baap re, itna power, so much power to the central government. They will trample upon the rights of the citizens." As a matter of compromise between Federalist and non-Federalist, first constitutional amendment was introduced in 1791 that provided for Bill of Rights, which were not part of original Constitution of USA. So the purpose of Bill of Rights was to restrict the power of the government. So fundamental rights promote a limited government or unlimited government. Limited, it promotes constitutionally. यानी सरकारें हमेशा limited होनी चाहिए. Unlimited सरकार जो है वो लोगों के लिए. पालखी वाला जी said a beautiful statement. He said, "Charters of liberty give rise to power and not vice versa." कितनी अच्छी बात उन्होंने. I like this. I once many years back I posted this also. He said, "Charters of liberty give rise to power and not vice versa." हमने अपनी लिबर्टी में से सरकार को पावर दी है, ना कि सरकार की पावर में से हमें लिबर्टी. Charters of liberty give rise to power and not vice versa. So fundamental rights ना हो तो फिर क्या होगा? Bholu walking by the lanes of old Rajendra Nagar, he will be arrested by the constable unnecessarily. Constitution says no person shall be deprived of his liberty except procedure established by law or life. So Bholu cannot be arrested by the constable because there is no such procedure established by law, and Article 20 prohibits any such punishment unless he has violated a law. So most of the time fundamental right is restricting the power of state and promoting constitutionalism. यानी constitutionalism means एक ऐसी सरकार जो limited. कहाँ नहीं है judiciary? North Korea भी, no country in the world doesn't have judiciary. In monarchical countries or dictatorial regimes, if somebody commits murder, he is taken to the king. एक dictatorship में कोई चोरी करता है तो उसको king के पास ले जाते हैं. नहीं, everywhere there is a judiciary, but the difference is in democracy, judiciary is independent. So having judiciary is not a prerequisite to democracy. Even in North Korea, Saudi Arabia, or any other country, you will have judiciary. India, US, but having a judiciary which is protecting the rights, a judiciary which is independent. That is the prerequisite. So government's unlimited threat to democracy. A limited government is a prerequisite for democracy. So we will settle for limited government. ये क्वेश्चन 3 बार आया है पिछले 5-6 सालों में. So Universal Declaration of Human Rights, 10th December 1948, very, very important. Other than fundamental right, which of the following parts of Constitution reflect the principles of UN Universal Declaration of Human Rights? It is preamble also, it is directive principles also, and it is fundamental duties. Article 29 of United Nations Declaration of Human Rights says all persons have the duty towards the community to which they belong for the free and full development of their personality and all. So Article 29 of United Nations of Universal Declaration of Human Rights, 10 December 1948, also provides for fundamental duties. So fundamental duties also there, DP, SP is also there, and of course preamble to hai hi. So we will settle for all the 338 ka will settle for D. Now in India, legal services, although this question actually was something which has actually, because transgender is directly not mentioned in the Legal Services Authorities Act 1987. But anyways, UPSC has given an answer. Sabse pehle we will eliminate senior citizen because it is not mentioned in the act. Senior citizen will get free legal aid or not will depend upon the state. Will depend upon the state. So it says as per the law in India Legal Services Authorities. So this is eliminated. We will eliminate 4. Now members of OBC in the Legal Services Authorities Act, download the law, you will see who are entitled to legal aid. There is no mention of OBC. Victims of human trafficking, women, those under detention, SC, ST, there is no mention of OBC. So we will eliminate 3 and 4, 3 and 4, we will only get 1 and 2. Technically transgender is also not mentioned, but most of the states are giving that to transgenders. Okay, so that their rights are not violated. So the best answer, and that UPSC gave an answer, that is 39A, 1 and 2. Okay. Now we have 21. This is again, this question was a beautiful question from law. This we have studied in law. Okay. Mitakshara. This question says ki Mitakshara was a civil law for upper caste and Daya Bhaga was a civil law for lower caste. बिल्कुल नहीं, दोनों upper caste के लिए था. So this is a wrong statement. This was actually a very factual question. In the Mitakshara system, the sons can claim right to property during the lifetime of father, wherein Daya Bhaga it is only after the death of father. This is a correct statement. Mitakshara system deals with the matters related to property held by male members of the family, whereas Daya Bhaga system deals with the matters related to property held by both male and female member. Now this, if you see the statement, sabse pehle, this statement we will eliminate. 1 we will eliminate. So we have either 2 or 3. And Mitakshara is actually Daya Bhaga, this statement is correct. Sabse pehle 1 is eliminated. So what do you get? If 1 is eliminated, what do you get? Either B or D, and B is correct. So we will settle for 2, but I honestly don't expect an average aspirant to know this answer because this was on a tougher side. So all questions cannot be answered. Okay, then the UPSC actually will examine your answer scripts. That how can a person get 80%? If you will score somewhere more than 75, they'll check ki kahan se aa gaya bhai. So getting my point na? So it is B for Bombay. 2 only. We adopted, now this is the easiest question I want you all to. What is the difference between British and our parliamentary model? British parliament is supreme or sovereign, but our parliament is limited. Yes. British parliament is, अब एक example देते हैं. Supreme Court in UK is because of a law passed by Parliament. Constitutional Reforms Act 2005 led to the establishment of Supreme Court in UK. So the birth of Supreme Court in UK is because of a law passed by Parliament. Can the Supreme Court strike down a law passed by Parliament? Then the Parliament will remove the Supreme. A Supreme Court in India has got its birth from the Constitution. Supreme Court in UK has got its birth from a law passed by Parliament. Okay. So a body that has come into existence because of a parliamentary law cannot be exercising judicial review over the body that led to its establishment. So Parliament in UK is sovereign, while in India it is limited. In India, matters related to constitutionality of amendment are referred to Constitution Bench, Article 145 of the Constitution. Any question related to constitutional interpretation or Article 143 advisory jurisdiction shall be referred to a Constitution Bench where minimum number of judges would be 5. So British Parliament is supreme sovereign, but India power of Parliament is limited. Correct. Matters of constitutionality are referred to Constitution Bench. This is also correct. So we will settle for C. अब सुनिए. Comparing Constitution में क्या क्या question पूछा है UPSC ने? What all questions they have asked in mains? One question they have asked principle of equality between America and India. 3 साल पहले पूछा. Second question they asked difference between the presidential election of France and India because an election was that year. That was a current affairs question. Third question, they ask the difference between the judiciary of UK and India. What all next they can ask? First, they can ask difference of judiciary between UK and India. This they have asked. They can ask again also difference of judiciary between America and India. Please go and see comfortably federal judiciary versus integrated judiciary. Or क्या question they can ask? Federalism se they can ask more and more questions because a lot of issues are going on from federalism. You see these questions would be asked in comparing constitutions in year. Pehla, compare judiciary of US versus India, UK versus India. Second, federal structure in Canada, US, Australia and India. So these provisions, I think you must be prepared before they ask. So both the statements are correct. We will settle for C, both 1 and 2. Again, this question was on a tougher side. Okay, Gopal Swamy Iyengar committee suggested that a minister and a secretary. So this is a wrong statement and this is a correct statement. We'll settle for B. Actually, this question was something which is related to more of a what you call factual thing. Ki itna factual nahi hona hai. There are few more questions which we will see over this. So don't go into these facts. Every year there will be 1 or 2 questions which they will ask from somewhere. If we will prepare for this question, next year they will ask a different question. Okay, so here it is 78B for Bombay, that is 2 only. Okay, Department of Personnel was constituted on the recommendation of ARC. ARC is important for governance. Okay, that you know. Now this is right to privacy. KS Puttaswamy versus Union of India. Easiest question till now. One of the easiest, that is Article 21. So is right to privacy a absolute right or a qualified one? Among all the fundamental rights, which right is said to be the maximum absolute? Article 17. Untouchability is abolished and practice in any form is forbidden. So kaha jata hai scholars mein 17 has the maximum amplitude of absoluteness. Okay. Now this question has been eliminated by UPSC. Okay. Why this question has been eliminated? Because 2 statements are actually wrong. It says in India there is no law restricting candidates from contesting from 3 constituencies. No, there is a provision. A candidate can contest only from 2 constituencies. In Lok Sabha election, Devi Lal ji contested from 3. This is the correct thing. As per the existing rules, if candidate contests from 1 Lok Sabha election, and he should bear the cost of by-election if he vacates. कह रहा है कोई जीत गया फिर रिजाइन दे दिया उसने और बाय इलेक्शन हुआ तो उसका खर्चा वो उठाएगा. If someone wins an election and he resigns and there is a by election, then he will bear the cost of by election. So many people. Mulayam Singh Yadav ji won from 2 constituencies. Lalu Yadav ji 2004 won from 2 constituencies. Narendra Modi ji won from 2 constituencies. So many people won from 2 constituencies. There is no such thing that if they will resign, they will bear the cost of by election. So first and third statement are wrong while second statement is correct. Now this is something which is, there were more concerns with this. There is no law restricting the candidate in 1 Lok Sabha. Now they say which of the following is in 1997 this was contested from 3 Lok Sabha constituencies as per the existing rules. If a thing, now this question has been eliminated because of multiple reasons. Fun, I think there is one option that is what you call. Okay, I got it. Okay, so here there is some option that has been changed, but here this question has been eliminated by UPSC. What you are required to know: Representation of People Act 1950, Representation of People Act 1951. उसमें भी क्या जानना है? Representation of People Act 1950 में 3 चीजें. What is the qualification to be a voter? First important thing. Second important thing: recent issue of service voter. RPA में क्या जानना है? Recent issue of service voter. Second important thing. Third, NRI voting. Okay, that is something which is in news. And schedules के बारे में थोड़ी जानकारी होनी चाहिए. RPA 1951 में you should know first about section 123 corrupt practice, section 126 electoral silence, section 126A exit poll, most important section 8 disqualification. All these things you should know in RPA 1951, and the things that I said, this question has been eliminated by UPSC. Now this again is a factual question. Ab right to city is an agreed human right. The very inception of the question agreed human right makes it a wrong statement. Why? Because the Constitution of India does not provide for any human right explicitly. There are either legal rights or there are constitutional or fundamental rights. So first statement is a wrong. Right to city and second, third statement are correct. Right to city gives every occupant of the city right to claim public spaces. Right to city means state cannot deny public service facility to the unauthorized colonies. ये दोनों सही है, so we'll settle for D for Delhi. Just remember one thing always. Whenever you are dealing with a particular issue, just read the statement. It says right to city is an agreed human right and UN Habitat monitors commitment made by each. Did you ever hear that there is a right to city in India and unauthorized colonies are not being removed? Getting my point? So ऐसा कोई human right and एक और बात, Protection of Human Rights Act 1993, National Human Rights Commission. There is National Human Rights Commission will enforce only those rights which are guaranteed by the Constitution or any law or international covenant which India has agreed. यानी human right नाम का कोई legal concept, getting my fundamental right, legal right, or those rights, जैसे UN Convention on Refugees, India has not signed. UN Convention on Elimination of All Forms of Discrimination Against Women, India has signed. So dear students, what I am trying to emphasize कि human right को तो protect human rights commission भी नहीं करता है. Human right commission उन rights को protect करेगा जो या तो constitution से guarantee हो रही है या तो इंडिया ने कोई convey. So as such human rights has not been defined in the constitution or any statute. That what do you mean by human right? Protection of Human Rights Act may, if you will read what rights National Human Rights Commission can impose, all those rights that are technically enforced by law or those which India has signed and ratified. जैसे UN Convention on Elimination of All Forms of Discrimination Against Women, UN Convention Against Corruption, some conventions of ILO, some we have not signed. जैसे UN Convention on Refugees 1961 हमने sign नहीं किया. Additional Protocol we have not signed. Principle of non-refoulement, if refugee will come, we will not send them back, we have not signed. So some conventions we have signed and many conventions we have not signed. Technically, human rights as such has not been legally defined in the Constitution or in fundamental rights. Even in Protection of Human Rights Act, they have not defined the human right. And there is no such thing that UN Habitat will monitor. First statement is incorrect. We will settle for D for Delhi 2 and 3. Now, with reference to the India, consider the following statement. Judicial custody means an accused is in the custody of concerned magistrate and such accused is locked up in police station, not in jail. गौर से सुनिए. सबसे पहले, when a person commits an offense, okay, offense can be basically broadly for your nature, it should be cognizable or non-cognizable. ठीक है? What is a cognizable offense? For that offense, for which investigating officer does not require a warrant. यानी किसी ने मर्डर किया. मर्डर इज अ सीरियस ऑफेंस और इजी ऑफेंस. सीरियस, इसके लिए इन्वेस्टिगेटिंग ऑफिसर को वारंट की जरूरत नहीं है. ही विल नॉट रिक्वायर अ वारंट, ही विल गो एंड अरेस्ट. सो बेसिकली द ऑफेंस कैन बी कॉग्निजेबल और नॉन कॉग्निजेबल. इन नॉन कॉग्निजेबल ऑफेंस इन्वेस्टिगेटिंग ऑफिसर रिक्वायर्स warrant. In cognizable offense, investigating officer does not require a warrant. Next important thing. Then you have compoundable and non-compoundable offenses. Those offenses where compromise can be reached between both the parties are compoundable, and those where compromise cannot be reached are non-compoundable. And the most important, bailable versus non-bailable. Bailable matlab those offenses for which you have to get bail. And non-bailable doesn't mean that you will not get bail. ये तो सबसे बड़ा confusion है. Non-bailable means court may give you bail or may not give you bail. Bailable means छोटे मोटा किसी ने किसी को टक्कर मार दी, little bit. So bailable means the moment you present yourself in the court has to give you bail. Court doesn't have an option. So what is a bailable offense where bail becomes a right? What is a non-bailable offense? It's not that you will not get bail. Here bail is not a right. Court may give bail or may not give bail. So bailable offenses वो है जहां छोटे मोटे offenses जहां आप जैसे ही गए आपको bail मिलनी ही मिलनी है. Non-bailable का मतलब है bail मिलेगी कि नहीं ये court decide करेगा. So if there is a bailable offense, then you will present yourself and court will give you bail. If it is a non-bailable offense, you will present, court may give you. Generally क्या होता है in a non-bailable offense, lower court never gives bail. Generally, they don't give. Sessions Court give. In most of the cases, Sessions Court also shy away from giving. One of the judges were also saying that they should give. But mostly it is given from High Court. Lower Court doesn't want to touch. So it's not that in non-bailable offense you will not get bail. You may get bail or may not get bail. So what is a judicial custody? For example, Chomu was arrested for an offense. So police placed Chomu before the magistrate. Now police will say, we want to ask him, please give him a police custody. So judge will say, why do you need police custody? So we want to ask him about the investigation and all. So the judge will say, okay, how many days? They will say 14, judge will say 3. 3 days, Chomu is given police custody. If Chomu is given judicial custody, then Chomu will go to the jail. Police will only see Chomu from a distance. They cannot touch Chomu also. So what is a judicial custody? You are in the custody of judge. You will be in jail. Police cannot meet you also without the permission of judge. Police custody means you will go with the police and they will talk to you harmoniously. Generally what I see, police will ask for 14 days. But judge will give only, because 14 days mein to, judge will usually give 3 to 4 days. So what is a judicial custody? Once Chomu is presented before magistrate, prosecutor will say, Hujur, we want 15 days of judicial custody, 14 days. Then judge will say, no, 3 days are enough. Chomu sent to police custody for 3 days. Now these 3 days, Chomu will be questioned by the police. One thing, some cases when there is an apprehension of some, then judge will say, okay, Chomu's lawyer will also be there when the investigation or the questioning is going on, so as to secure his well-being. Okay, so what is a judicial custody? In judicial, if you committed an offense and judge sent you to judicial custody, then you will go like this and you will enter jail. Police can see you, but they cannot touch, even talk to you without the permission of the jail. So in judicial custody, you are secured, you are in the custody of the judge. Now let's see. Judicial custody means an accused is in the custody of magistrate, and such accused is locked up in police station, not in jail. This is a correct or wrong statement? This is a wrong statement, because judicial custody mein he doesn't go to police custody, he goes to jail. During judicial custody, police officer in charge of the case is not allowed to interrogate the suspect without the prior approval of the court. Yes, they cannot ask without the approval of the court. So this is, second is correct. 82 we will settle for B. Okay. Now this is an interesting question. इसमें difference of opinion है. सुनिए. सबसे पहले, there is a concept called as Babu Model Act. In last month's current affairs, did you see the lecture? Model Act can be a question this year. In last 3 years, they have asked prison 2 times. If you add all the ancillary questions also, prison has been asked 3 to 4 times. So if you ask ancillary questions, so in last 2-3 years, UPSC is giving extra attention to prison, payroll and all these things. Now listen to me. There are various provisions in the law. I don't want to go into CRPC section 438, anticipatory bail, or 434, or many provisions are there. Now listen to me very carefully. First of all, what is the difference between payroll and follow? Okay, सबसे पहले, follow is, सबसे पहले entry 4 of the state list, that is list 2 is prison. So prison falls under the state list. So every state has their own rule. In some states you have service. In some states you have service. I have a friend in Bihar who is in state probation service. एक gazetted officer. उनका काम क्या है? Anybody who applies for remission or anybody who applies for any such thing, he goes to his home, he sees, okay, socio-economic background, educational background, family background. He will prepare a secret report and he will submit to the government whether that person should be given remission, payroll or not. Now what is follow? He only explained me कि कैसे चल रहा है. In jail, different states have different rule, but I'll give you a common sense. In jail 30 days is not a month. 25 days is a month, 27 days is a month, 24 days is a month. मतलब, if your behavior is good, every month you will earn 6 days. That will be counted as in jail, but that will be getting. So month will only, for example, you are given 24 months. So every month will be of 24 days only if you are having good behavior. Ultimately, you will save 3 to 4 months. And this month which you have saved, you can release earlier, or in between you can go out. So in follow 1, follow is something which you have earned. When you go out of the jail, then that day will also be counted in your, for example, you have earned for 2 months. You go out and come back. Those 2 months which chill out with your friends outside, those 2 months will also be counted as in jail. So follow is granted for good behavior. It is earned. Payroll kya hai? Somebody, and follow is mostly for long term. Follow is mostly for long term punishment. Payroll kya hai? Although it differs from state, it's a beautiful topic. I don't want to go deeper into because we are running short of time. Payroll mein kya hai? Somebody who is in jail, unfortunately, God forbid, Dadi ji ka dehant ho gaya. Somebody dies. So immediately he will be allowed 2 days payroll to go and achieve the function. So payroll is not a matter of right. It is not earned, and it may be for long term or short term. And it also, payroll mein pure discretion is of the state government. In follow, although there is a discretion, your behavior and all, but the level of discretion is very less because you have earned those days by good behavior. So that is, every state has the entry 4 of the state. अब एक model act, हाँ, जहाँ से बात शुरू हुई थी. Many things, जैसे parliament, those things in state list, parliament or the ministry prepares a model act. Model act मतलब states may incorporate them, or it is not binding. State may incorporate them or may not. Let's see. When a prisoner makes out a sufficient case, payroll cannot be denied to such prisoner because it becomes a matter of his right. Payroll becomes a matter of right, or follow becomes a matter of right? Follow. So this statement is a wrong. Payroll तो pure state का discretion है, मिल भी सकता है और नहीं भी मिल सकता है. State governments have their own prison rules on prisoners release on payroll rules. Correct है या सही है? बिल्कुल. Entry 4 of the state list is prison. Every state has made its own rules. So this is a correct statement. This is a wrong statement. We will settle for. हाँ, इसमें गलती है ऑप्शन में, मैं बताना भूल गया. It is written in the UPSC 1 only, 2 only, both 1 and 2, neither 1 and 2. UPSC में लिखा है 1 only, 2 only, both 1 and 2 and neither 1 and 2. What should be the answer? क्या आंसर होना चाहिए? Second statement is correct, first statement is wrong. So answer होगा B, 2 only. यहाँ printing है, misprint है थोड़ा. So this is 1 only, 2 only, both 1 and 2 and neither 1 and 2. This is mentioned in the question paper of UPSC. I checked there. So there is a misprint here. So it should be B, 2 only will be the correct answer. Okay. So prison is under which list? Public health is under which list? Say, agriculture is under which list? Education is under which list? Education, सब states कौवा उड़ चिड़िया उड़ हाँ, so बीच में concurrent list except one, agricultural education. State list entry 14, agriculture including agri. So there is one education which is not in concurrent list. It is agricultural. क्यों? Because red soil, mountainous soil, alluvial soil, those various soils. So you need different research for different state. So agriculture is in state list including agricultural education, while all other education is in concurrent list. So now, which ministry implements Scheduled Tribe and Traditional Forest Dwellers Recognition of Forest Rights Act? This is Ministry of Tribal Affairs. Law may be here. This is D, 84D. Now this says a legislation which confers executive or administrative authority unguided and जैसे ही आया unreasonable discretionary. Always remember one thing. Article 14 is a 2-month child. It will always accompany mother. जैसे, whether nota should be there or not. Any petition is filed in Supreme Court. Kerala temple authorize whether women should be allowed to enter Sabrimala, whether nota should be given or not, whether right to privacy should be there or not, whether right to die with dignity should be there or not, whether decriminalization of politics should happen. कोई भी petition Supreme Court में file हुआ, एक article जरूर mention होगा, that is Article 14. That is Article 14. So what is Article 14? Article 14, any action of the state can be challenged for being unreasonable. So Article 14 is like salt, it will go in most of the foods. So even if there is a petition on nota, even if कुछ भी challenge होता है, every action of the state should be a reasonable action. So that is a violation of Article 14. So आप देखिएगा Young Lawyers Association case, Joseph Shine case, then you have Navtej Johar case, you have KS Puttuswamy case, कोई भी case देखिएगा एक article जरूर mention होगा, Article 14. The principal basis of Article 14 is the action of the state should not be an unreasonable. The action of the state should be reasonable. Anything which is discretionary is a violation of. Anything which is discretionary is a violation of Article 14. वो क्लेम करेंगे 21 का वायलेशन, साथ में 14 भी लिखेंगे. इफ दे विल क्लेम वायलेशन ऑफ 14, उसके साथ पिटिशन में दे विल राइट 14. इफ दे विल क्लेम वायलेशन ऑफ 25, दे विल राइट 14. इफ दे विल क्लेम वायलेशन ऑफ 17, दे विल राइट 14. इफ दे विल क्लेम श्रेया सिंगल वायलेशन ऑफ 19, दे विल राइट 14. कुछ हो ना हो 14 तो जाए. क्यों? एवरी एक्शन ऑफ द स्टेट शुड बी अ रीजनेबल. कोई भी काम, कल गवर्नमेंट places a tree over there, somebody will challenge that under 14 क्योंकि कहेगा कि this action is unreasonable. So now let's read the question. A law which confers on executive or administrative authority unguided, uncontrolled discretionary power, which of the following articles of constitution is violated? कौन सा article violate हो रहा है constitution? 14, 28, 32 और 44? It is Article 40. क्यों? क्योंकि वर्ड यूज हुआ है डिस्क्रिशनरी, और डिस्क्रिशनरी इज अगेंस्ट अनरीजनेबल. डिस्क्रिशनरी मतलब कि आई एम गिवन द डिस्क्रिशन, ओके, you 3 will become IAS, you will become IPS, you 3 will join foreign service, you will go to civil account service, audit and account service, postal service. Getting my point na? Defense state service, defense account service, DANIX, Puducherry police service, assistant commissioner RPF. मतलब I distributed. This is reasonable, this is unreasonable. So actions of the state should not be discretionary, they must be reasonable. So Article 14 is oxygen. It is every petition that is filed in Supreme Court. I can talk till tomorrow morning. So many cases Supreme Court में हमेशा देखता हूं एक आर्टिकल जरूर लिखेगा. That is mention of Article 14. So हर एक्शन जो स्टेट का है वो रीजनेबल होना चाहिए, वो डिस्क्रिशनरी नहीं होना चाहिए. So it is a violation of Article 14. So a legislation 85 we will settle for A. Now let's see this. Which is the essential feature? Which of the following we will settle for A in question number 85? Which of the following in Indian polity is an essential feature that indicates federal character? What is the federal character? What is the federal character? बताइए. Federal character is independence of judiciary. क्यों? गौर से बताते हैं. Without independence of judiciary, how will federalism sustain? When the founding mothers and fathers were drafting the constitution, any federal country cannot sustain for 36 seconds without an independent judiciary and written constitution. Australia was also having a non-federal setup and unwritten constitution, chilling out. But when they opted for federalism, they drafted a written, क्योंकि कोई फेडरल कंट्री कैनॉट सस्टेन फॉर 2 minutes विदाउट रिटन कॉन्स्टिट्यूशन. अब मैं बताता हूं. नो फेडरल कंट्री, देयर विल बी अ डिस्प्यूट बिटवीन सेंटर एंड स्टेट. ठीक है, यूएस में भी टेक्सास वर्सेस फेडरल गवर्नमेंट ऑफ यूएसए, स्टेट ऑफ वेस्ट बंगाल वर्सेस यूनियन ऑफ इंडिया, सो मेनी केसेस. इफ देयर इज अ सेंटर एंड स्टेट गवर्नमेंट, देयर विल बी अ डिस्प्यूट. सो देयर नीड टू हैव एन इंडिपेंडेंस. हो ही नहीं सकता है कि डिस्प्यूट नहीं हो, चाहे वो इंडिया हो या यूएसए हो, डिस्प्यूट तो होगा ही होगा. सो यू नीड एन independent judiciary. So independent judiciary is a very important character of federalism. कौन सा? Article 131. Article 1. Dispute between center and one or more state. Dispute between center and some state versus other states. Dispute between 2 or more states. So we have question number 86. Union legislature This is not a constituent essay, not necessary. Union cabinet from regional parties, not necessary. Fundamental rights, there can be fundamental rights even in unitary country or federal. But one thing that is important की independence of, अब सुनिए US को देखते हैं, बहुत important. US में a judge will adjudicate if there is a dispute between Texas versus federal government. हो सकता है डिस्प्यूट हो जाए नॉर्थ डकोटा वर्सेस फेडरल गवर्नमेंट, हो सकता है डिस्प्यूट हो जाए कैलिफोर्निया वर्सेस फेडरल गवर्नमेंट, हो सकता है डिस्प्यूट हो जाए अलास्का वर्सेस फेडरल गवर्नमेंट, हो सकता है डिस्प्यूट हो जाए मियामी वर्सेस फेडरल गवर्नमेंट. सो इन एवरी स्टेट, इन यूएस सेनेट, एवरी स्टेट हैज 2 मेंबर. नाउ लिसन टू मी वेरी केयरफुली. यूएस की राज्यसभा में, इन द राज्यसभा ऑफ यूएस, एवरी स्टेट हैज 2 मेंबर. अ स्मॉल स्टेट लाइक नॉर्थ डकोटा और साउथ डकोटा, नॉर्थ डकोटा और साउथ डकोटा से भी 2 मेंबर है. और कैलिफोर्निया विच हैज 53 मेंबर्स इन लोकसभा हैज 2 मेंबर्स इन राज्यसभा. कैलिफोर्निया हैज 53 मेंबर्स इन लोकसभा बट दे हैव 2 मेंबर्स इन राज्यसभा. एल्बर्टा हैज 3 मेंबर्स इन लोकसभा, 2 मेंबर्स इन राज्यसभा. सो बी इट अ बिग स्टेट और अ स्मॉल स्टेट, ऑल ऑफ देम वुड हैव सेम इन राज्यसभा बट दे मे हैव डिफरेंट इन लोकसभा. सो फेडरलिज्म को इंश्योर करने के लिए बड़ा स्टेट हो या छोटा स्टेट हो, राज्यसभा में सबको सेम नंबर मिलेगा, लोकसभा में सबको पॉपुलेशन के हिसाब से मिलेगा. सो टू इंश्योर फेडरलिज्म, लोकसभा दे मे हैव अ डिफरेंट नंबर बट इन राज्यसभा दे विल हैव एन इक्वल नंबर. नाउ व्हाई दिस प्रोविजन हैज बीन इनकॉर्पोरेटेड, प्लीज अंडरस्टैंड. अब सुनिए, अब इसको लिंक करते हैं. इफ देयर इज अ डिस्प्यूट बिटवीन टेक्सास एंड अमेरिकन फेडरल गवर्नमेंट, हु विल डिसाइड? अगर टेक्सास और फेडरल गवर्नमेंट में लड़ाई होता है, कौन डिसाइड करेगा? सुप्रीम कोर्ट ऑफ अमेरिका. एवरी जज ऑफ सुप्रीम कोर्ट ऑफ अमेरिका इज अपॉइंटेड बाय द प्रेसिडेंट. उसको अपॉइंट करते हैं प्रेसिडेंट एंड इज अप्रूव्ड बाय सेनेट. एवरी जज इज अपॉइंटेड बाय द प्रेसिडेंट एंड अप्रूव्ड बाय सेनेट. एंड सेनेट में एवरी स्टेट हैज. सो इफ द जज इज बायस्ड, if the judge is biased, who will favor the center, not the state, will not be impartial, then the Senate will not approve. Getting my point now? The Supreme Court of America will decide if there is a dispute between center and state. So whenever a judge of Supreme Court is appointed, the states have an equal say through the Senate. So every state has equal representation in Senate, otherwise wo approve kare. I give you an example. In 2016, when it was the last year of presidency of Barack Obama, Facebook was very popular at that time. He wrote a post at Facebook. He was from Democrat Party and Republicans were having majority in Senate. Republicans said, you appoint a judge, we will not approve that judge. आप appoint कीजिए, हम लोग approve ही नहीं करेंगे. So he wrote a post over Facebook where it is written in the constitution that in the last year of presidency, president cannot appoint a judge. Thus, the Republicans were saying in Senate, ki, we will not approve the judge. You are going last, this is your last year. Why are you appointing a judge? Let the new president appoint the judge. So he wrote a Facebook post where it is written in the constitution, can outgoing president cannot nominate a judge. So, US में फेडरलिज्म को इंश्योर करने के लिए, in order to ensure federalism, a judge is appointed by the president but approved by the US Senate. And in US Senate, UP of US, California, or small state of US like North Dakota, they both have equal. हर स्टेट से 2 मेंबर हैं और 50 स्टेट है, तो कुल मिलाकर वहां 15 to 2 100 मेंबर्स. So ऐसे होगा, judge will always be unbiased. He will not favor a big state because he's appointed by the president, but he's approved by the Senate. And Senate में every state has an equal number. लोकसभा में कैलिफोर्निया के 53 मेंबर्स हैं, राज्यसभा में 2. नॉर्थ डकोटा के लोकसभा में 3 मेंबर्स है, राज्यसभा में 2. So irrespective of their number in House of Representatives, they have equal number in Rajya Sabha, that is US Senate, so as to maintain independence of judiciary, which is if there is no independence of judiciary, center will trample upon the rights of the state. So independence of judiciary is a prerequisite for कोई भी फेडरलिज्म आधा घंटा सर्वाइव नहीं करेगा अगर इंडिपेंडेंट जुडिशरी नहीं. सो व्हाट आर द 2 बेसिक कैरेक्टरिस्टिक ऑफ फेडरलिज्म? रिटन कॉन्स्टिट्यूशन एंड इंडिपेंडेंस ऑफ जुडिशरी. एक ऐसी जुडिशरी जो सेंटर को ना फेवर करे, विच विल नॉट फेवर द सेंटर, विच विल बी इम्पार्शियल. So this is A. Next we have, which of the following term defines state? This is a very, very easy question. They have given long list, but it says a community, a person permanently occupying. a definite territory independent of external control and organized government. A politically organized people, definite territory. अब यहाँ क्या कह रहा है? Government to maintain law and order, protect their natural right. Do you think in constitution natural right is mentioned? No. So we will directly eliminate. A number of persons who are living in different territory by their own culture, tradition and government. Culture and tradition. State maybe there can be many. Our brothers and sisters from Naga community have beautiful culture. Our Mizo community have beautiful culture. Article 371A says no act of parliament. No act of parliament related to the religious or cultural practices shall apply to the state of Nagaland unless the legislative assembly by a resolution so decides. So parliament का कोई भी law Nagaland पे apply नहीं करेगा अगर उनके culture से जब तक उनकी legislative assembly approve ना. So we have a beautiful Mizo culture. Article 371G. So different, it is not necessary that in a state everyone will have their own culture. A society permanently living in a definite territory with a central authority, independent judiciary has nothing to do. Acha, in Saudi Arabia, North Korea, judiciary is independent. No, is it not a state? It is a state. So we will eliminate B, C and D and we will settle for A. Next, with reference to Indian judiciary, consider the following statement. A retired judge of Supreme Court can be called back to sit and act by the Chief Justice with the prior permission of President. High Court has the power to review its own judgment. Most controversial question. Ab sun lijiye. In Article 137 of the Constitution, it is written that Supreme Court can review its own judgment. High Court के लिए Constitution में कहीं नहीं लिखा हुआ है. Nowhere it is written in the Constitution that High Court can review its own judgment. But there is a basic legal jurisprudence. There is a basic legal jurisprudence that any court, there is a basic legal jurisprudence, any court that has a power of judicial review and acts as a court of record can review its own judgment. So Supreme Court के लिए लिखा हुआ है Constitution में. Article 137 Supreme Court can review its own judgment. High Court के लिए ऐसा लिखा हुआ नहीं है. Directly not mentioned. Indirectly, a court which has power of court of record and judicial review also can act as a review its own judgment. UPSC ने question पूछा High Court can review its own judgment. This is statement UPSC ने wrong मांगा. क्यों? Because this is not directly mentioned in the Constitution. For High Court it is not directly mentioned. For Supreme Court it is directly. For High Court it is implicit, indirect, hidden within that. For Supreme Court it is direct. Or most of the students opted for this as correct. क्योंकि ये लिखा हुआ है कि any court which has a power of judicial review and court of record also can review its own judgment. But UPSC says that why are you taking it from inference? Because the same is not mentioned in the Constitution. UPSC का कहना है कि कहाँ Constitution में लिखा हुआ है? Constitution में तो सिर्फ Supreme Court का लिखा है, High Court का तो लिखा ही नहीं है. So that is why UPSC took this statement as wrong and High Court has the power to review its own judgment is wrong. If we will cut and write Supreme Court, it will become a correct statement and this is a right statement. So question number 88, we will settle for A1 only. Now this is the easiest question. With reference, there is only one citizenship and one domicile. You cannot have OBC from two states. It is banned, it is wrong. You cannot have OBC from two states. You can have only from one state. So there is only one citizenship and one domicile. A citizen by birth can become the head of state. बिल्कुल नहीं. In America, a person who is a citizen by birth can only become president. In India, सिर्फ लिखा हुआ है he should be a citizen of India. Citizen किसी भी तरीके से बने, birth से बने, descent से बने, registration से बने, naturalization से बने या incorporation से बने. यानी किसी भी तरीके से आप citizen बने तो आप you are citizen by any means you can become president. America में you are citizen by birth. For example, an Indian couple working in Texas. After few years, they will get the citizenship of America, but they cannot become president because they are not citizen by birth. India में बस लिखा हुआ है Article 52, there shall be a president of India. Later down the line, you will see he should be a citizen of India. ऐसा कहीं नहीं लिखा हुआ है he should be citizen by birth. It says a citizen by birth can only become head of the state. ये wrong है. अमेरिका के लिए right है, इंडिया के लिए wrong है. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. Do you think showing disloyalty to the Constitution is a ground of termination of citizenship? Article 9. If you take the citizenship of a foreign state, termination. Then unlawfully communicating with enemy during war is a ground for termination of citizenship. And most importantly, if you take citizenship by fraud, then also your citizenship will be terminated. कह रहा है, if a person is given citizenship, his citizenship can never be withdrawn. This is wrong. ये statement एक wrong है, ये statement एक wrong है और ये statement correct है. There is only one citizenship, so we will settle for A1 only. Now this was a very good question of 2021. It says, which of the following factors constitutes the best safeguard of liberty? अब सुनिए, committed judiciary. Committed judiciary means a judiciary that is committed to government. Committed judiciary was in news during emergency. So can a committed judiciary protect fundamental rights? No. Committed judiciary will be committed to. So committed judiciary is not the safeguard of liberty. It is against the liberty. Centralization and elected government is not there. So what do you need for liberty? You need separation of powers. So D is the correct answer. Concentration of wealth. See the easiest question. सीधा question article 39C से पूछ दिया. Operation of economic system should avoid concentration of. भारत की अर्थव्यवस्था में wealth concentrate ना हो. So under the Indian Constitution, concentration of wealth violates Article 39C of the Constitution. What should be the answer? DPSP, that is 39B. So this is 39C. So we have 91B for Bombay. What is the position of right to property in India? Article 300A. सुनिए क्या कह रहा है. Article 300A says no person shall be deprived of his property. No person shall be deprived of his property save by authority of law. कह रहा है no person means this is available to the citizens as well as non. Article 19(1)(f) was only available to the citizens, but Article 300A is available to the citizens as well as non-citizen. Let's see. Right to property is a legal right available to citizens only. Wrong. Legal right available to any person. Chalo, this is a correct. Let's see. Fundamental right nahi, neither a fundamental right nor legal. Wrong. So correct answer would be B. What is a right? Rights are legally protected interests. Rights are legally. So every constitutional right is also a legal right. You cannot say that a constitutional right is an illegal right. So rights are legally protected interests. So 92 we will settle for B for Bombay. What was the status of India on 26 January 1950? It was sovereign democratic republic. बाद में add हुआ sovereign socialist. So B is the correct answer. These two words were added by 42nd Constitutional Amendment Act that came into force on 3rd January 1977. Okay. So what was the exact constitutional status? It is sovereign socialist secular democratic या sovereign democratic republic. फिर पूछ दिया. अभी आपने दो बार देखा है constitutional government. Third time they are asking a question, and to your surprise 2023 also. Again they have asked this year also. What do you mean by constitutional government? So a constitutional government means a representative government, a government whose head enjoys nominal power, a government limited by the constitution. So what should be the answer? D. Okay. Now this question UPSC, I could have showed you. This question UPSC has lifted from a page called as padmaawards.gov.in. Just type Padma Awards on Google, you will find. वहीं से ये question pick किया है. Okay, that is, we don't have time, otherwise I would have showed you. Consider the following statements. Padma Awards are titles. सीधा बालाजी राघवन वर्सेज यूनियन ऑफ इंडिया. सुप्रीम कोर्ट ने कहा ये अवार्ड हैं, ये टाइटल नहीं है. So Padma Awards or Padam Shri and Bharat Ratna are not titles, they are just awards. Okay, so ये है. Padma Awards were suspended once. No, they were suspended 2 times between 78-79 and 93-97. So statement wrong है. Number of Padma Awards is restricted. Bharat Ratna is restricted to 5. एक साल में 3 लोगों को भारत रत्न दिया जा सकता है, ना कि 5. So 3 people can be given Bharat Ratna, not 5. So all the 3 statements are wrong, and UPSC asking which is not correct. So we will settle for D, 1, 2 and 3 only. This question has been taken from a website padmaawards.gov. This is a statement. UN Capital Development, United Nations Capital Development Fund and Arbor Day have recently recognized Hyderabad. Actually, Arbor Day Foundation and Food and Agriculture. This statement is wrong. ये current affairs का question था. This UNDP was not involved. So एक wrong statement है. फिर कह रहा है Hyderabad was selected for recognition for a year following commitment to maintain the urban forest. ये correct है. So first statement is wrong and second is correct. So क्या कहेंगे? Statement 1 is not correct and statement 2 is correct. So we will settle for D for Delhi. So this is 97. We will settle for D. Okay. Roger, हाँ, this was a tough question because UPSC is called unpredictable. इन्होंने सीधा 4 क्वेश्चन स्पोर्ट्स से पूछ दिया. They asked 4 questions because nobody was reading sports. And next year they will make it sure that they will not ask a single question. Okay, and suddenly they will ask 5 questions because they know that they cannot trap students until they bring the element of unpredictable. Because students are very intelligent and UPSC wants to bring that. So this question was asked. Second question is more interesting, that we will see. American golfer Tiger Woods was the first winner of this award, Laureus World Sports Award. ये correct है. He was the first. इसमें कुछ नहीं है, factual है, बस मैं बता देता हूँ. The awards were received mostly by Formula 1. No, ज़्यादातर award tennis players ने जीता है. So this statement is wrong and maximum award is won by Roger Federer. So first and third statements are correct. We will settle for C for Calcutta 98C. Now third is very interesting question. 99 कह रहा है the official motto of this Olympic is a new world. नहीं, official motto is together. So this is a wrong statement. And sports climbing, surfing, skateboarding are included in this Olympics. ये correct है. So second statement is correct. First is wrong, which is purely a factual question. इसमें कुछ समझाना नहीं है. So we will settle for B, 99B. Now this is a beautiful question. For example, India has played 20 tests and won 15 tests, while England has played 15 tests and won 14 tests. Who is better there? Or India has played 15 tests and won 14, and England has played 20 tests and won 15. Who is better? India. So ICC Test Championship में it is not decided on the basis of number of matches. It is decided on the basis of number of points. Getting my point now? So now let's see the question. The finalists were decided by the number of matches. No, ऐसे तो जो country सबसे ज़्यादा खेलेगी वो rank 1 हो जाएगी. Getting my point? So it is not decided on the basis of number of matches, but on the basis of points after minimum number of matches that you have played. New Zealand was ranked ahead of England because it won more matches. Matches जीतना तो यहाँ कोई criteria था ही नहीं. So again, both the statements are wrong, and we will settle for 100 D, neither 1 and 2. 22 में you have less question. Now in this question, कुछ नहीं करना है. Whenever contempt of court is taught, one thing is said, that contempt of court is not defined in the constitution. एक line सबसे important है, contempt of court is not defined in the constitution. Now statement 3 says Constitution of India defines civil and criminal contempt. Yani statement 3 is wrong. So what we will do, first we will eliminate 3. We are left with 1, 2 and 4. So in India, Parliament is vested with powers to make laws on contempt of court. Answer is B. गौर से सुनिए. पहले कह रहा है HN Sanyal Committee's recommendation contempt of court was enacted. So अब ये student को नहीं मालूम है कि which committee recommended contempt of court. This, even if you don't know, you know this statement that contempt of court has not been defined in the constitution and Parliament has made contempt of court act. So one thing that every student knows, that contempt of court has been enacted by Parliament and contempt of court has not been defined in the constitution. So third statement says that contempt of court has been defined in the constitution. So we will eliminate third statement. Third को eliminate करके, and fourth is correct. Third is eliminated and fourth is correct. What should be the answer? I am again coming. It says contempt of court was added on the recommendation of HN Sanyal Committee, which I assume that nobody, less number of students know. But next it says that contempt of court has been defined in the constitution, which everyone knows that contempt of court article 129 and 215 has not been defined in the constitution. So it is a wrong statement. So we will eliminate the third statement, and then contempt of court act has been made by Parliament. So third statement is wrong and fourth statement is correct. So what should be the answer? Third statement is wrong, we will eliminate this, and fourth statement is correct. So we will settle for 1, 2. This question can only be done by elimination, because UPSC knows that you don't know that which committee recommended contempt of court. You're getting this point? So we'll settle for B. लेस, इसमें ज्यादा क्वेश्चन नहीं है, इस साल उन्होंने बहुत कम क्वेश्चन पूछा था. With reference to India, consider the following statement. Government law officers and legal firms are recognized as advocates, but corporate lawyers are not. सबसे पहली बात, advocate is under the Advocates Act. So there is anybody who is enrolled with the State Bar Council, and this is a wrong statement where it says government law officers are advocates, but patent attorneys are not. They both can only be advocate if they are registered. So this statement is a wrong statement. फिर कहता है, now see, Bar Council has the power to lay down the rules related to legal education. Absolutely correct statement. You have Bar Council which will regulate legal education in India. So this is second 12B is correct. ये कह रहा है government officers जो होंगे वो advocate होंगे, बाकी नहीं होंगे. This is a wrong statement. Okay. Consider the following statement. Now this is very easy. A bill amending the constitution requires the prior recommendation. No. A money bill, financial bill 1 requires the prior recommendation of president, not an constitution amendment bill. So first statement is wrong. So a bill amending the constitution requires a prior recommendation. No. When a constitution amendment bill is presented to the president, it is obligatory for the president to give assent. This is correct, given in Article 368. A constitution amendment bill must be passed by both the houses, and there is no provision for joint sitting. There can be joint sitting for ordinary bill, but not for constitution amendment bill or money bill. So second and third statements are correct. First statement is wrong. We will easily settle for B for Bombay. Now, Constitution of India classifies ministers into 4 ranks: cabinet minister, minister of state, independent charge, minister of state and deputy minister. ऐसा कुछ भी classification constitution में, constitution only uses the term council of ministers, and the term cabinet is mentioned only in article 352. So there is no such classification given in the constitution that who will be a cabinet minister, who will be a minister of state. All such classification is, it says Constitution of India classifies ministers into 4 ranks. Nowhere in the constitution there is any such classification. Constitution तो कह रहा है Article 74, the Council of Ministers shall aid and advise the President. Article 75, the Council of Ministers will be appointed by President on the recommendation of Prime Minister, and Prime Minister will be appointed by the President at his pleasure. So there is no such classification. यानी ऐसा कोई. अच्छा, everyone knows that what percentage can become minister? जो भी लोकसभा की strength है उसका 15% of Lok Sabha can become minister. So second statement is a correct. The total number of ministers in union government, including the prime minister, shall not exceed 15% of the members of Lok Sabha. Second is a correct statement. First is a wrong statement. Second was added by 91st Constitutional Amendment Act 2003. So again, question number 14 will settle for B. Now this is the easiest question. What are the exclusive powers of Lok Sabha? Ratify emergency, both Lok Sabha and Raj Sabha. Pass no confidence motion, only Lok Sabha. Impeach the president, both Lok Sabha and Raj Sabha. So what is the exclusive power of Lok Sabha? It is 2. B, 2 only. With reference to anti-defection, consider the following. That nominated member cannot join party within 6 months. Ulta hai. Nominated member can join party within 6 months, cannot join after 6 months. So this statement is a wrong statement. The law does not provide for time frame. यही तो issue है. 10 schedule में कोई time नहीं दिया हुआ है कि speaker has to take decision within that. So Supreme Court time and again says speaker has to take decision within a reasonable time. So ये statement correct है क्योंकि speaker को decision लेने के लिए कोई time mention नहीं है. So this is a correct statement. The law does not provide for time frame which the presiding officer has to decide, and nominated member cannot join within 6 months. Actually, nominated member can join within 6 months. So it is not cannot, it is can. Wrong statement, correct statement. Question number 16 will settle for B. B. Okay. 17. Attorney General and Solicitor General are officers who are allowed to participate in the meetings of Parliament. Wrong. Only attorney. In the constitution there is no mention of solicitor. Solicitor General is mentioned in Contempt of Court Act 1971. Solicitor General is not mentioned in the constitution, he is mentioned in the law. So पहला तो statement ये wrong हो गया. According to Constitution, Attorney General submits his resignation. No, he doesn't. There is no provision of resignation and all such things. There is a convention that government changes, Attorney General submits his resignation, but there is no such provision in the Constitution. So this statement is also wrong. This is wrong. We will settle for D for Delhi. Now, with reference to the writs, C, Supreme Court has time and again said mandamus can be issued against a private company if it is performing a public duty, and mandamus will not lie against a company even though it may be a government company because it is not performing a public duty. It can only be issued if it is performing a public duty. So this is also a correct statement. In quo warranto, there is no local standi. Anybody can move Supreme Court for invocation of fundamental rights. So statement 1, 2 and 3 both are correct. All the three are correct. Okay. So we will settle in question number 18, D. Now this is a tricky question. Ayushman Bharat. कुछ भी पढ़ने की जरूरत नहीं. Just it says Ayushman Bharat, private and public hospitals must adopt it. Do you think every hospital in India has adopted it? No. It says it aims to achieve universal healthcare. Every citizen should be part of it ultimately. Just think that I am a citizen. I have never been approached to become. So this is a second statement is an absolutely wrong statement that every citizen has to become part of Ayushman. Don't you think if there is such provision, it will be challenged in court? So there is no binding. So we will eliminate 2 and 1 and 3. First statement is also wrong. So the only correct statement is D. Jahan bhi must, shall, compulsory, most of the time it will be, most of the time, not always, but most of the time you have to be more cautious. It is likely to be wrong. So यहां कुछ पढ़ने की जरूरत नहीं थी. कह रहा है every citizen has to become part of Ayushman Bharat. You will think I am also a citizen. Am I a part of Ayushman Bharat? No. So we will be eliminating the second statement right at the onset. We are left with 1 and 3. Only thing we have to see whether the first statement is a correct or not, which says private and public hospital must adopt it. So we will eliminate. So there is 3. 19B for Bombay, that is 3. Now Deputy Speaker, this was an expected question. Rule 7 and Rule 8 of Rules of Procedure and Conduct of Business of Lok Sabha. कहता है, the date of election of Speaker will be determined by President and date of election of Deputy Speaker will be determined by Speaker. Date of election of President will be determined by, date of election of Speaker will be determined by President and date of election of Deputy Speaker will be determined by. So this is not mentioned in the Constitution. This is mentioned in Rule 7 and Rule 8 of the Lok Sabha. So it says, as per the rules of procedure and conduct of business of Lok Sabha, the election of Deputy Speaker shall be held as such days with the Speaker fixed. This is a correct. ये Rule 8 कहता है कि Deputy Speaker के election की date Speaker तय करेंगे. Rule 8 of the Lok Sabha says that the date of election of Deputy Speaker will be fixed by the Speaker. So this is a correct statement. फिर कह रहा है there is a mandatory provision that deputy speaker should be from opposition party. ऐसा कोई भी mandatory provision नहीं है. This is a convention, not a provision. So this is a wrong statement. Deputy speaker has the same power as speaker when presiding over. This is a correct statement. And there is a well-established parliamentary practice that deputy speaker motion is moved by the speaker and seconded by the prime minister. ऐसा कोई practice नहीं है कि motion to elect deputy speaker is seconded by the prime minister. So this is wrong. This is wrong. 2 and 4 are wrong while 1 and 3 are correct. So we will settle for option A, that is 1 and 3 only. Now again this is a factual question. कोल कंट्रोल इज द मेजर, एक एक्ट है स्टैटिस्टिक्स कलेक्शन एक्ट, उसमें सीसीओ इज द सोर्स ऑफ स्टैटिस्टिक्स, कोल स्टैटिस्टिक्स इन गवर्नमेंट ऑफ इंडिया. इट मॉनिटर्स द प्रोग्रेस, करेक्ट. इट हियर्स एनी ऑब्जेक्शन, ये तीनों करेक्ट है एंड दिस इज रॉन्ग. सो दिस इज व्हाट यू, दिस इज एक्चुअली रॉन्ग. इट सेज coal mining companies deliver the coal to the end users in time. How will the coal controller decide how will that be delivered? So the fourth statement is wrong. While this is mandated by the Statistics Act, this is a statutory provision and these two are always there. So 1, 2 and 3 is correct and fourth is wrong. So we will settle for option A. Now this is an easy question. If an area is brought under 5th schedule, okay, the state would have a special category state. Not necessary. Jharkhand has a 5th schedule. 10 states in India. Gujarat have a 5th schedule. Is Gujarat a special category state? No. So having fifth schedule does not lead to special category, bilkul nahi. So it will be converted into union territory. So Jharkhand, Gujarat has scheduled area, it will be converted into union territory. No, again eliminated. It will have local self-government. Local self-government will not be by fifth schedule, by Panchayat extension to Scheduled Areas Act 1996, not by fifth schedule. So again this is eliminated. So the answer is, this will prevent the transfer of land from tribal people to non-tribal. This is 73A. One thing I would like to add, in last 7 to 8 years, they have asked almost every second year from 5th and 6th schedule. 5th and 6th schedule is extremely important from the perspective of UPSC, be it prelims or mains. Go through the Tribal Advisory Council and autonomous district councils and regional councils. Okay, so the corresponding article is Article 244. The Tribal Advisory Council under 5th schedule, the Autonomous District Council under 6th schedule. What are the powers? Assam, Meghalaya, Tripura, Mizoram. There are 10 autonomous district councils. Ek aur cheez, Manipur doesn't come under 6th schedule. Assam, Meghalaya, Tripura, Mizoram. Manipur doesn't come under 6th schedule, but there are still some autonomous district councils. They are by an act of legislature. Yani कहने का मतलब, in Assam also I can show you now, there are 3 autonomous district councils under 6th schedule in Assam. But there are more autonomous district councils, not just district councils in Assam, which are not under 6th schedule, but by a law by the state legislature. So always remember, there are autonomous district councils under 6th schedule. There are other autonomous district, Ladakh, Leh and Ladakh Hill Council. That is also, but it is not under 6th schedule. Similar is in Manipur, but it is not under 6th. So there can be a hill council even outside 6th schedule under a law passed by the state legislature. Manipur is in news. They may ask a question about the hill councils in Manipur, which are not under the 6th schedule, and similar hill councils are there in Assam, where they have 3 autonomous district councils under 6th schedule and other hill councils under the law passed by the state legislature. So 5th schedule, 6th schedule, and this is answer is A, 73. Now, India Sanitation Coalition is a platform to promote sustainable sanitation, is funded by Government of India and World Health Organization. Factually, this is what you call incorrect. National Institute of what you call Urban Affairs is an apex body, and this is a coalition with UNICEF. Okay, so again, Ministry of Housing, Urban Affairs, this is a wrong statement. Okay, so this is something which is, both the statements are wrong. So we will settle for 74D for Delhi. Okay, 74D for Delhi. With reference to T-Board, T-Board is a statutory body, bilkul. There is a T-Board Act. Okay, headquarter is in Kolkata. So T-Board is a statutory body, correct. T-Board headquarter is in Bangalore, wrong. Overseas office is in Dubai and Moscow, correct. So first is correct, third is wrong. Third is wrong, third is wrong. So it is D, 1 and 4. ऐसे भी देख ले, it is a regulatory body attached to Ministry of Agriculture. नहीं, Ministry of Commerce, because it is mainly a cash crop. Getting my point na? So Ministry of Commerce, statutory body, correct. Headquarter is in Kolkata. Regional overseas office is in Dubai and Moscow. This is correct statement. This is correct statement. 1 and 4 are correct. 2 and 3 are incorrect. We will settle for 79, D for Delhi. Okay. Now there are few questions. Due process of law. This is an easy one. There is a debate between fair application of law and principle of natural justice. Principle of natural justice is broad, and fair application of law is limited. A better word would be fair. See, हुआ क्या, क्यों इतने डाउट है? In Menka Gandhi versus Satwant Singh एक केस था. In Satwant Singh case, Supreme Court ruled right to travel abroad is a part of right to life. So right to travel abroad and return is a part of right to life. This was actually ruled before Menka Gandhi case, in Satwant Singh case. In Menka Gandhi case, the regional passport officer gave her a notice. Ma'am को एक notice गया. You have to surrender your passport, which she asked that what is the reason. So it was challenged in Supreme Court that every administrative order should be backed by a reasonable thing. So because the reason was not given. So already Supreme Court has ruled in Satwant Singh case कि भाई right to travel abroad and return is a part of Article 21 personal liberty, क्योंकि Article 19(1)(d) कहता है right to travel throughout the territory of India. राइट टू ट्रैवल, उसमें बाहर जाने की बात नहीं है. सुप्रीम कोर्ट ने कहा अच्छा, इफ समबडी इज अ म्यूजिशियन एंड ही हैज टू परफॉर्म हिज इन लंडन, Article 19(1)(g, right to travel any, right to practice any profession. How can he practice his profession without right to travel abroad? He is a YouTuber. How can he travel abroad without, how can he practice his profession without traveling abroad? Supreme Court says there is a cricketer. He has to play a cricket match in London. How can he practice his profession unless he is having the right to travel abroad? So Supreme Court said Constitution directly says right to travel throughout the territory of India. But right to practice your profession is incomplete without traveling abroad. So to ensure Article 19(1)(g, you should have an implicit right to travel abroad. He is a businessman. If he is not right to traveling abroad, how will he practice his right to practice any trade, occupation, profession or business? This is an interesting case. I don't want to stretch, but in Satwan Singh case, Supreme Court says right to travel abroad is a part of right to life and right to personal liberty and also to return. Menka Gandhi case में Supreme Court ने कहा the actions of the government should be reasonable and should not violate principles of natural justice. Principle of natural justice has come from a maxim just naturally. Just natural. उसके 3 major element है. पहला, nobody can be a judge of their own case. I cannot be a judge of my own case. If I am the judge and my younger brother is arguing, I will recuse myself because there is a relation. Getting my, and direct है तब तो बिल्कुल. Nobody can be a judge of their own case. Everybody is entitled to fair trial. सबको fair trial मिलना चाहिए. And the most important, audi alteram partem. Audience means sunna, alterum means alternate, partum means party. It says 3 principles of natural justice: fair trial, getting my point, nobody can be a judge of their own case, and audi alterum part. I cannot give a judgment unless I have heard A also and B also. Audi, audience means sunna, alterum means alternate, partum. So principle of natural justice is foundation of justice. Any justice dispensation body has to adhere to that. So principle of natural justice includes fair and application of law. Both the answers A and C are correct, but the most appropriate one would be A, that is 11A. Okay. Now this again is a controversial one. In India, prisons are managed by state government with their own rules and regulation. Ye absolutely correct hai. In India, prisons are governed by Prisons Act 1894, which expressly kept the subject of provinces. So, although statement A, both statement 1 and 2 are correct, and 2 is the correct explanation. So, it is both the statements are correct. But whether 2 is the correct explanation remains a matter of debate. Kyun? Because Indian Prisons Act 1894 put prisons under the state. But prison as a state list matter became by Government of India Act and by entry 4 of the Constitution of India. So both the statements are correct, but in 1894 whether this statement would apply or not is a debatable one. So the most appropriate answer would be A, but this can also be an answer. Both statements are correct, but statement is not a correct explanation. Most likely A, but it can. This is one question which is a bit debatable after the principle of natural justice. So here best answer would be A, but B can also be an answer. What is the chief purpose of Fir aa gaya? What is the chief purpose of Constitution? Chief purpose of Constitution is to define and limits the power of government. That is C. Constitution. Now in India, which of the following Constitution amendment was widely believed to be enacted to overcome judicial interpretations of fundamental right? सीधा जानते हैं क्वेश्चन कहां से उठाया है? You download first Constitution Amendment Act. At the beginning of first Constitution Amendment Act, it is given objectives and reason. There were many people who were debating that whether the answer should be First Amendment or 42nd Amendment. But this statement has been taken from the first Constitutional Amendment. If you will go and download the first Constitutional Amendment Act, objectives and reasons of the first Constitutional Amendment, it says that this amendment is being brought to overcome judicial interpretation. कह रहा है which of the following constitution amendment was widely believed to be enacted to overcome the judicial interpretation of fundamental rights? कौन सा ऐसा कॉन्स्टिट्यूशन अमेंडमेंट है जो इसलिए लाया गया था कि जुडिशियल इंटरप्रिटेशन फंडामेंटल राइट को ओवरकम करने के लिए? एट द ये ऑब्जेक्टिव्स एंड रीजंस ऑफ द फर्स्ट कॉन्स्टिट्यूशन अमेंडमेंट एक्ट में ये लिखा हुआ है that this constitution amendment is being brought to implement to overcome the judicial interpretation of fundamental rights. So some people were confused about this, but this is a direct statement that is taken from the objectives and reasons of the bill. So we will settle for first Constitutional Amendment Act. Okay. Now this is the easiest question. Fourth easiest question which we have dealt. Which of the bodies are mentioned in the constitution? National Commission for Backward Classes, bilkul. Article 338B added by 102nd Constitutional Amendment Act. National Human Rights Commission, bilkul nahi. Protection of Human Rights Act 1993. So this is a statutory body. Law Commission is neither a statutory body nor a constitutional body. It is merely a executive body. So ye bhi nahi. Consumer Dispute Redressal Commission is a statute, so it is not mentioned in the constitution. Keh raha hai, which is a constitutional body? Only one. So question number 15 we will settle for A1 only. Now this is now 16. If the election of president is declared void, all acts done by him becomes invalid. कह रहा है, मान लिया president every 5 year on 25th July president takes oath. Every 5th year president takes oath on 25th July. Unfortunately, so there have been vacancies in office 2 times. Otherwise, president will take oath on 25th of July. For example, the president takes oath on 25th July. After 2 months, Supreme Court declares the election as invalid. So whatever work done by the president in these 2 months, they cannot be declared as invalid. ये constitution में लिखा गया है कि अगर प्रेसिडेंट के इलेक्शन को इनवैलिड किया जाएगा तो उन्होंने अब तक जो काम किया उसको इनवैलिड नहीं. सो एनी इफ द इलेक्शन ऑफ प्रेसिडेंट इज सेट असाइड, द एक्ट्स डन बाय द प्रेसिडेंट ऑटोमेटिकली बिकम इनवैलिड. द स्टेटमेंट सेज इफ द इलेक्शन ऑफ प्रेसिडेंट इज डिक्लेयर्ड वॉइड, all acts done by him becomes invalid. So this is a wrong statement or correct statement? Constitution says कि if the election of president is set aside, अगर president के election को set aside करते हैं, अभी तक उन्होंने जो काम किया वो invalid नहीं होगा. All the acts done by president will not be invalid. यहाँ कहता है it will become invalid. So this is a wrong statement. Election for the post of president can be postponed on the ground of, ये साफ लिखा गया है कि वैकेंसी विल नॉट बी अ रीजन टू पोस्टपोन द इलेक्शन, अदरवाइज कुछ ना कुछ वैकेंसी हमेशा रहेगी. ये सो वैकेंसी विल नॉट बी अ ग्राउंड टू पोस्टपोन द इलेक्शन. इट सेज इलेक्शन फॉर द पोस्ट ऑफ प्रेसिडेंट कैन बी पोस्टपोन्ड ऑन द ग्राउंड, इट कैन नॉट बी पोस्टपोन्ड. सो अगेन दिस इज अ रॉन्ग स्टेटमेंट. व्हेन अ बिल इज प्रेजेंटेड टू द प्रेसिडेंट ऑफ इंडिया, कॉन्स्टिट्यूशन प्रिस्क्राइब्स टाइम लिमिट. नो पॉकेट वीटो. सो आर्टिकल 111 of the constitution, there is no time limit mentioned in the constitution. So all the 3 statements are wrong. It says कह रहा है constitution time limit देता है, पर actually में constitution time limit नहीं देता है. So this is a wrong statement. It says that president का election legislative assembly के vacancy से postpone किया जा सकता है. No, there cannot be a postponement under any circumstance. It says if the election of president is held invalid, whatever he has done till date also becomes invalid. Wrong है. If the election is invalid, whatever he has done till date always remains valid. So all the 3 statements are wrong. We will easily settle for D for Delhi. With reference to finance bill, money bill in parliament, consider the following statement. Just remember one line. Okay. Finance bill is also a kind of money bill. It is also a classification of money bill. Now let's read the question. When the Lok Sabha transmits finance bill to Raj Sabha, it can amend or reject the bill. So if finance bill is all the principles of money bill is applied on finance bill, can be rejected by Raj Sabha? No. मैं फिर से कह रहा हूं, finance bill has all such qualification of a money bill. Can Raj Sabha reject it? No. Raj Sabha cannot. कह रहा है if when Lok Sabha transmits finance bill to Raj Sabha, it can amend or reject the bill. Wrong. क्योंकि it is a money bill, it cannot be rejected or okay. It can be, suggestions can be given, but okay. When the Lok Sabha transmits money bill to Raj Sabha, it cannot amend or reject, but it can make recommendations. Yes, it cannot amend or reject, but it can definitely make recommendations. In case of disagreement, there is no joint sitting for money bill, but a joint sitting can be there for finance bill. Bilkul nahi. There cannot be a joint sitting for finance bill also because it is also like a money bill. So na money bill के लिए joint sitting हो सकता है, ना फाइनेंस बिल के लिए जो खाली फाइनेंशियल बिल 1 एंड फाइनेंशियल बिल 2 के लिए ज्वाइंट सिटिंग हो सकती है. So there is a difference between, now here there is ample of confusion. You remember this graph, you will never make mistake. Financial bill, financial bill, financial bill 1, financial bill 2, money bill. Okay, always remember, financial bill, there is financial bill 1, financial bill 2. Money bill ka you have similar finance bill. So all finance bills are financial bills, but all financial bills are not finance bills. So there can be a joint session for financial bill 1, there can be a joint session for financial bill 2, but there can be no joint session for finance bill. The question is not asking financial bill, the question is asking finance bill. This I have explained half an hour in the class. So ये finance bill की बात कर रहा है ना कि, so finance bill is also exposed to all the conditions of money bill. So can there be a joint session? No. क्या money bill के लिए joint session हो सकता है? नहीं. So getting now financial bill 1 and financial bill 2 में joint session हो सकता है बिल्कुल, but money bill में no. Since finance bill is a kind of money bill, so there can be no joint session. So do not get confused between finance bill and financial bill. All finance bills are financial bills, or all financial bills are not. All finance bills are financial bills, but all financial bills are not finance bills. Okay. We have 2-3 questions left, don't worry. So when Lok Sabha transmits finance bill to Rajya Sabha, it can amend or reject it? No. It can only give recommendations, it cannot amend or reject. It can make recommendations, yes. But joint sitting becomes necessary for no. There can be no joint sitting for finance bill. There can be a joint sitting for financial bill. So third statement is wrong. First statement is wrong. 2 is correct. So we'll settle for 17A only 1. With reference to scheduled area, when within a state, notification of an area as scheduled area is given through order of president, correct hai. President can declare an area as scheduled area. The largest administrative unit is district, smallest is block. This is also correct. The chief minister submits a report to home ministry. Bilkul galat. The governor submits a report to the president. So third statement is wrong and first and second statements are correct. So we will settle for only 2. That is B for Bombay. Now this is easy. Supreme Court has held in some judgment that reservation policies made under Article 16 Clause 4 would be limited by Article 335 for maintenance of efficiency of administration. Bilkul sahi hai. Article 335 of the Constitution says while giving reservation, administrative efficiency should not be compromised. M. Nagraj case and you have Jarnail Singh case. So the efficiency, though this is a correct statement. Article 335 of the Constitution defines efficiency of administration. Efficiency of administration has not been defined in the Constitution. So this is a wrong statement and this is a correct statement. We will, both statement 1 is correct and statement 2 is incorrect. So we'll settle for 20 ka C. With reference to Home Guard, consider the following. Home Guards are named under Home Guards Act and rules of central government. Home Guards come under state government. So पहले ही ये statement एक wrong statement है. Role of Home Guard is to serve an auxiliary force to police in maintenance of internal security. बिल्कुल नहीं. They help in communal incidents or other relief, but not directly in internal security. So both the statements are wrong. Now the union government is raising certain border wing home guard battalions having. क्यों? सुनिए. Home guard local लोग होते हैं. Home guards are local people. All the border states, they are raising home guard. क्यों? For example, we are living in the class. Suddenly you know your batchmates in your batch. Suddenly some 4 people come from other batch. Immediately you will say that this person is not from our batch, he is from some other batch. So central government is raising some home guard battalions who will be local people. So if there is an infiltration, they will be in a better position to identify rather than central armed police force which doesn't know that who is a local and who is not a local, especially when the culture is same on both the sides. इसीलिए सेंट्रल गवर्नमेंट होम गार्ड का बहुत रोल होता है बिकॉज दे आर लोकल. सो सेंट्रल गवर्नमेंट इज रेजिंग, दिस इज अ करेक्ट थिंग. Central government, although generally home guard come under the state government, so this is a wrong statement. Role of home guard is not for internal security. Okay, they are just an auxiliary force to support. So first and second is wrong, third is correct. We'll settle for only one. Now this was a tougher one. Official Secrets Act ke sare provisions. Okay, something which is it was in news, but if you have gone through the law, then it is. It says unauthorized wearing of police uniform. Ye section 6 hai. So this is correctly matched. Misleading police officer. This is section 7 of Official Secrets Acts. Indian Evidence Act mein nahi hai. This is section 7 of Official Secret Act. So ye wrongly matched hai aur ye correct match hai. अभी recent law आया है 2019 में शादियों में in marriage. Okay, so to avoid that celebratory firing or after election कुछ गोलियां वोलियां, so all that has been it has been made a criminal offense. So celebratory gunfire with endanger personal safety arms amendment act, ये correct है और ये correct है. Misleading a police officer is Official Secret Act section 7, not Indian Evidence Act. So first statement is correct, second statement is wrong, and third statement is correct. So we'll settle for 1 and 3, which is only 2. So 52 ka B. Now, Major Dhyan Chand Khel Ratna Award for most spectacular and outstanding performance over last 4 years. Bilkul sahi. Arjuna Award is also for Lifetime Achievement Award. No, it is also for last 4 years. So Lifetime Achievement to nahi hai. This is a wrong. Dronacharya honor eminent coaches who have successfully. This is absolutely correct. So first is correct and third. Rashtriya Khel Ratan Puruskar to recognize contribution made by sport persons even after their retirement. No, that is not Rashtriya. This Rashtriya Khel Ratan Puruskar is NGO or corporate entity for promotion of sports. So this is a factual question. You can go. Isme kuch samajhna nahi hai. This is purely fact. This is a wrong statement. This is a wrong statement. 1 and 3 are correct statement. We will settle for B, only 2 only. Okay. Now this is a very easy question. Kyun? Because 44th Chess Olympiad was held in India and it was in news like anything. So this was the first time Chess Olympiad was held in India. Absolutely correct. And in Asia after 30 years. Official mascot was Thambi. Ye bhi sahi hai. Only thing is male. So Vera Menchik for winning team in open section is trophy. Winning team in women's section is ye actually इन्होंने क्या किया उल्टा कर दिया. For open section it is Russell Cup or for women's section it is Vera Menchik. So what they have done, they have changed. For Vera Menchik is for women's section and open section it is Hamilton Russell Cup. So both third and fourth statement are wrong and first and second statement are correct. So we'll again settle for 56 ka B, that is only 2. Constitution Day is celebrated on 26 November to promote constitutional values. Bilkul sahi. On 26 November 1949, Constituent Assembly set up drafting committee. Drafting committee was set up even earlier, and most importantly, Article 394 of the Constitution. 15 articles of the Constitution. Article 394 and 14 other articles. Kitne hue? 14 plus 1. 15 articles of the Constitution came into force on 26 November 1949. 380 articles of the Constitution came into force on 26 January 1950. So on 26 November 1949, Constitution was adopted and enacted, and 15 articles of the Constitution came into force on 26 November 1949 also, related to Citizenship, Election Commission of India definitions. Other articles of the Constitution came into force on 26 January 1950. So 380 articles came into force on 26 January 1950. 15 articles came into force on 26 November 1949. और drafting committee तो पहले बनी थी. 26 November 1949 तो constitution was completed. So it is blatantly wrong to call that 26 November 1949 drafting committee was constituted. So second statement is wrong and first statement is correct. So statement 1 is correct, but statement 2 is incorrect. So we will settle for 65 ka C. Okay. So Janani Suraksha Yojana, it is a safe motherhood intervention of state health department. सीधा आपको मालूम है Janani Suraksha Yojana is for central government. So this is blatantly a wrong statement. Its objective is to reduce maternal and neonatal mortality. बिल्कुल सही. Promotes institutional delivery. बिल्कुल सही. Objective is to include providing public health facility to sick infants. हमेशा याद रखिए. शिशु सुरक्षा योजना It is not Janani Suraksha Yojana, but in front it is Sishu Suraksha Yojana. So this statement is wrong. Second and third is correct, and first is also wrong. So we will settle for only two. We'll settle for only two. Question number 81. So they are asking schemes continuously. Schemes, though you cannot. They have asked a scheme that what you call Gati Shakti Yojana. So in mains. So schemes, I think, has to be done very comprehensively. Now anemic Mukt Bharat strategy. So it is prophylactic calcium supplement. Actually उन्होंने क्या किया है? This बस यहाँ prophylactic iron supplement. Prophylactic iron supplement. So this goes wrong. It runs a campaign for delayed cord clamping. ये सही है. It provides periodic deworming. ये भी सही है. Non-nutritional causes. This is also correct. So this is correct. This is also correct, and this is also correct, while this is wrong because of prophylactic iron supplement. So we'll settle for 2, 3 and 4. This is 82 ka C. Acha, now it says India's public system largely focuses on curative care with limited preventive and promoting and rehab. Absolutely correct. Pura health system इस चीज पे है कि कोई बीमार हो गया, somebody who has faced illness, not those to prevent illness. So it says, if you see, there is a official data that most of the money is being spent on how to cure people, not how to prevent people from getting disease. So it says India's public sector health services largely focuses on curative care with limited preventive, promotive and rehabilitative care. This is a correct statement. Under India's decentralized approach, healthcare delivery, states are primarily responsible. Public health is a matter in state list. लेकिन आप बताइए, इंडिया में क्यूरेटिव केयर इज गिवन मोर अटेंशन एंड प्रिवेंटिव केयर इज गिवन लेस अटेंशन. दिस इज करेक्ट, बट हैज इट एनीथिंग टू डू विथ स्टेट्स बीइंग रिस्पॉन्सिबल? Even All India Institute of Medical Sciences, which is a central institution, also curative care is given more emphasis than because government is concerned about people's health. It is Article 47. In DPSP, only one place they have mentioned primary duties. Within DPSP also in Article 41, they have said government to the best of its capacity. पैसा हो तब करना, वरना मत करना. Article 41 says government to the best of its economic capacity. Article 47 says among its primary duties. So within DPSP also health is given a priority. You read the language of Article 41 with 47. So what I am concluding is, of course there is more emphasis on curative care, but that has nothing to do with federalism. Both the statements are correct, but statement 2 is not the correct explanation of. So both the statements are correct, but statement 2 is not the correct explanation for statement 1. So this is a what you call is the correct explanation. This is says are not. So statement B is the correct answer for question number 95B. According to Constitution of India, central government has the duty to protect states from internal disturbance. Seedha Article 355. It shall be the duty of union to protect every state from internal disturbance, external aggression, and ensure that every state is being carried as per the provisions of Constitution. Seedha Article 355 say this statement has been lifted. The term internal disturbance has been changed from Article 352, but it is still present in Article 355. 352 से डिलीट हुआ है, 355 में टर्म अभी भी मेंशन है, दैट इज इंटरनल डिस्टर्बेंस. The Constitution of India exempts state from providing legal counsel to a person held for preventive detention. Okay, so this is not such. In fact, a person under preventive detention has to be given an opportunity to represent as soon as possible. So this is a wrong. Pota Act में confession cannot be used as evidence. Listen to me carefully. The biggest reason why Pota Act was criticized, because confession given to an SP was used as an evidence. So उसका criticism इसीलिए होता था कि पुलिस को दिया गया confession admissible था. So confession given to the police was admissible. This was one of the biggest criticism of Pota, and the act was later repealed. It says cannot be used as evidence. In fact, in this law, it can be. Pota was criticized because whatever you say in the police custody was admissible in court. It says it cannot be used. In fact, it can be used as an evidence. So this statement is wrong statement, this statement is wrong statement, and this statement is correct. So we'll settle for only one. Now this is my favorite question. which is the last one. Okay. This question requires 50 minutes, honestly. It is the election of president. This is the last question, don't worry. The members nominated to either house of the parliament are also eligible to be included. We know Article 331. 2 members are nominated from Anglo-Indian community in Lok Sabha by 104th Constitutional Amendment Act. The same has been deleted forever. Matlab not deleted, not extended further. Article 333, up to 1 member can be nominated in the state legislative assembly from Anglo-Indian category. That provision also has been discontinued. But we still have nominated members in Rajya Sabha. There are nominated members in Rajya Sabha, but nominated members are not allowed to vote in the election of the president. Otherwise, the Republican character of India will get diluted. Otherwise, Republican character will get diluted. So, कह रहा है nominated members are eligible to be included in electoral college, voter list. So, this is a wrong statement because nominated member को election में vote करने का right president में नहीं है. They don't participate in election, they participate in impeachment of president. Next, higher the number of elected seats, higher is the value of vote. कह रहा है अगर किसी assembly में seats ज़्यादा हैं तो value of vote ज़्यादा होगा. अच्छा, let's see, just a second. It says value of vote of one MLA is equal to population of state divided by total number of MLAs. Ab statement says if the number of MLAs are more, then the value of vote will be high. अगर डिनोमिनेटर बड़ा होगा तो फ्रैक्शन का वैल्यू कम होगा या ज्यादा होगा? जितना बड़ा डिनोमिनेटर होगा फ्रैक्शन का वैल्यू उतना कम होगा. If the denominator is more, then the value of fraction will get less. If the denominator is less, then the value of fraction would be more. अब कह रहा है the value of vote of one MLA will be more if there are more MLAs. So if there are more MLAs, then the value of vote will go down rather than going up. Because value of vote of one MLA is equal to, ऐसे है 1/1000. Okay. The population of state divided by total number of MLAs. So अगर MLAs ज़्यादा होंगे तो value of vote, of course population is also a cause, but it is directly saying, now you read the statement. It says the members, this is the wrong, higher number of elected assembly seats, higher is the value of each MLA. This is a wrong statement. So first statement is also wrong and second statement is also wrong. The value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. Wrong. The value of vote of each MLA of Kerala is more than Madhya Pradesh. So this was a factual statement. Okay, so this is a wrong statement. Now, since 3 statements are wrong and the only answer which is given, so we'll go for only one. कह रहा है the value of vote of each Puducherry MLA is equal to, is more than Arunachal Pradesh. देखते हैं. Just one second. For example, 6 lakh at that time population of Puducherry. 6 lakh, just giving you an example. Arunachal, almost population में कुछ हजार का अंतर है. 1971, few thousand. Now in Puducherry, 6 lakhs divided by 30. There are 33 MLAs, 3 nominated and 30 elected. In Arunachal Pradesh divided by 60. Numerator is same, but the denominator is small for Puducherry. So the value of fraction will be high for Puducherry or value of fraction would be high for Arunachal Pradesh. Value of fraction would be high for Puducherry. कह रहा है the value of vote of each Puducherry MLA is more than each Arunachal MLA. So statement is correct. So we will settle for only one, that is 100. Now just you have stayed here for long, so we will be like we'll settle for option 1 in question number 100. I would just take 2 minutes, just follow this thing. We cannot be prophetic, we can be to the best of our ability, we'll try. Just follow, just go and complete your NCERT. Second, always remember this is a competition, nobody is at advantage. If a question is tough for you, it is tough for everyone, and pray that the question is tough, because if it is easy, cutoff will go very high. Read newspapers have become the most important thing. Whatever topics keep reoccurring, be it collegium, be it aspects of liberty, be it sedition, be it office of governor, be it UN, Habitat, be it G20, anything that is relevant, उस पे you make your own analysis. And the most important thing from mains point of view is governance. It is very, very important. There are few laws which are always in news. Right to Free and Compulsory Education Act, Right of Persons with Disability Act, Then there is Companies Act का CSR section, थोड़ा देख लीजिएगा. Okay, they will ask a question from these laws. Okay, then Maternity Benefit Act का analysis, the Legal Service Authorities Act. This question PESA has been asked at least 5 times. Panchayat Extension to Scheduled Areas Act 1996. Okay, Right of Traditional Forest Dwellers, मैंने कहा था, पूछ भी दिया. And Right of Traditional Forest Dwellers and Scheduled Tribe Act 2006. Land Acquisition Act 1894 as amended in 2012, in fact in 13. Amended version of Land Acquisition Act. So Right to Free and Compulsory Education Act, Right of Persons with Disabilities Act, CSR Provision of Companies Act, Maternity Benefit Act 1961 as amended in 2017, the Legal Services Authorities Act 1987, Panchayat Extension to Scheduled Areas Act, Right of Traditional Forest Dwellers Scheduled Tribe Act, Land Acquisition Act. अब आइए, महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट, Environmental Protection Act के some provisions, not all. Okay, then you have a right to, most important one, that is Right to Information Act, but this this will be Right to Information Act. Okay, next you have a very important law that is related to what you call a brief insight into. I wanted to give few more laws. Right to Information Act you do, Then you have this is what you call Companies Act. We have already written, right? Food Security Act. Food Security Act is another law that is very, very important. Okay, 3 more laws the Minister of Home Affairs and the Ministry is contemplating to overhaul. So have a brief idea about Law Commission of India. Very, very important. इसको लेके question आने वाला है. This time they have asked. It was speculative. And the brief background of CRPC. These days they are asking. ऐसा मैं पहले कभी नहीं कहता. But of late they are asking CRPC. A brief idea about CRPC and IPC. What is the difference between CRPC, IPC? Okay, all such important laws. That is something which is important. Few more laws. Land Acquisition Act is something which is very, very important. So 96 Food Security Act we have already seen. 2013 Companies Act, Environmental Protection Act, Right to Information Act, Right to Free and Compulsory Education, Right of Person with Disability Act, Maternity Benefit Act. Very important. Gram Nyalays Act 2008. 2008. These I am not making it compulsory, but at least know about Law Commission and basic things. Okay. One important thing, provisions related to UCC in concurrent list. आने वाला है question. Marriage, inheritance, adoption, maintenance, divorce. So concurrent list में UCC को लेके क्या क्या provision है, you must have an idea about that. And Gram Nyalays Act of course remains very, very important. Other than these laws, any law that remains consistently in news remains important. So you are not required to remember the section. बिल्कुल section नहीं याद रखना है. You just required to have an analysis and what the act achieves, principles and objectives of the law, और कोई organization ने अगर act पे कुछ commentary की है, that is something which is important. And one important act which I missed is वो law नहीं, you have Lokpal and Lokayukt Act, Central Vigilance Commission Act. These things you just go through. Okay, Central Vigilance Commission Act and Lokpal and Lokayukt Act. अगर टाइम मिले तो Protection of Human Rights Act, National Commission for Women Act, National Commission for Minorities Act, National Commission for Minority Educational Institution Act. थोड़ा ज़्यादा है पर क्वेश्चन करना, getting a Protection of Human Rights Act, National Commission for Women, National Commission for Minorities, National Commission for Minority Educational Institution Act 2004. So don't remember sections, just go through the brief and on internet you will find the synopsis of these laws. Out of these laws you mark point most likely, although I'm not somebody who can be very, most likely there would be questions in prelims as well as in mains. So what you need to do, you just need to be very calm at yourself. And one last thing, that don't lose patience. It is same for competition is same for everyone. Okay, so one thing that you can do to yourself, that do not reveal anyone that you're preparing for civil services. It creates undue pressure from the friends and the family. Make it very, other than your immediate family members, go through these laws and do a secondary, some reading on newspaper, something that is reoccurring in newspaper. What are the connotations of that issue? Some brief background search you do. Okay. And NCERT is undoubtedly, if you have missed by this time, I think that is an injustice to the preparation. To do proper justice, go through NCERT, stick to a basic material is something which is important. Okay, so we wrap up the conversation. Thank you. Have a wonderful evening.